Can I welcome members to the 56th meeting of the Committee for Justice? Can I also then take this opportunity to welcome Emma Sheehan to the committee as Deputy Chairperson? You're very welcome, Emma, to this committee. I've only been on it briefly myself a number of weeks, but it's a very, very good team and we're doing a lot of good work. Can I also wish to put on record my thanks and appreciation to the former Deputy Chair Deirdre Hargey for all the work she had put into the Justice Committee, even in my time and then of course before my time. I worked well with Deirdre. She was very, very good. She stepped in for me last week and I had to leave early. But I found her questions very, very good and her scrutiny second to none. So whilst we welcome Emma to the committee, we also were saddened to lose Deirdre. And I think maybe we would send a wee letter just of thanks for her service on the Justice Committee. Members may wish to say something at this point. Does any other member wish to say anything? No? Okay. Can I then advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are on airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rows. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that oral evidence session on the Justice Bill with the PSNI and also with Department of Justice officials on the Sentencing Bill pre-legislative scrutiny will be recorded by Hansard, and can I seek your agreement for this? Agreed?
Agreed.
Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matter under consideration? Can I ask, are any members have any interest to declare in relation to today's business? And if they have, they should do so now or when the particular matter arises. Danny, come on ahead.
He's still on mute.
Are you on mute, Danny, or is that the system?
Must be the system. Oh, here we go.
Let me in.
Go on ahead, Danny. Yeah, I hear you now, yep.
Happy days. Yeah, just a media family member, works for the probation board.
Yep, thank you. Any other members wish to declare at this stage? If not, I'll move on then. Just to remind you to declare if you see fit throughout the business. Agenda item number 1 is apologies. I have an apology from Patsy McGlowan. Can I ask members if there are any other apologies? Okay, can I advise members then that committee members Danny Becker and Doug Beattie are attending the meeting remotely, virtually. Agenda item number 2 then is draft minutes. Can I inform members that draft minutes of the meeting held on Thursday, the 20th of November are pages 5 to 20 of the meeting pack. Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 20th of November 25?
Agreed.
Agreed. Okay, I'll sign then. Cool. Agenda item number 3 is matters arising. Can I ask members if they have any matters arising from the minutes that they wish to raise at this stage? No? Okay. Agenda item number 4 then is the Justice Bill, Police Service of Northern Ireland, oral evidence. Can I refer members to pages 22 to 146 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from the PSNI on the Justice Bill? The committee had agreed to hear from the PSNI at the end of the evidence gathering on the bill to provide an opportunity to discuss issues that have been raised in the evidence from other stakeholders. Could I suggest that the committee takes each part of the bill or planned amendment in turn, with some opening remarks from the witnesses followed by questions from members before moving on to the next topic? The session will last for up to 1.5 hours, but another session has been provisionally scheduled for the 15th of January if all topics aren't covered within that time. So we will follow a certain agenda, if that's okay, Anthony, and we will go through it one part at a time, and then maybe talk about some of the planned amendments, and then some of the other amendments that's maybe coming forward from private members, if that's okay. The witnesses providing evidence today are Anthony McNally, Assistant Chief Constable, Jacqui Gillespie, Chief Inspector, and Jeff Logan, Grade 7 PSNI. You're very, very welcome to the meeting, and thank you very much for your attendance. Could I invite you to make an opening statement on the first one, the first part, which is the biometrics, if that's okay?
I had sort of pulled together some opening notes in an overarching manner. If they're not particularly long, well,
that's fine. If you want to do that, and then what we'll do is we'll break our questions into the parts.
Makes perfect sense.
Yeah, okay.
Thanks. So thank you, Chair, and thank you, members, for the opportunity to meet with you again in respect of this bill. As you will be aware, we last gave evidence on the 10th of April of this year, 2025. PSNI were advised of the amendments which we received on the 11th of November this year, so just over 2 weeks ago. We have since held a constructive meeting with the Department of Justice colleagues and provided feedback, much in the same vein as we will give to you here today. Here today, as you mentioned with me, Chair, just for your own benefit and that of the members, is Jeff Logan, who is a subject matter expert on biometrics, and Chief Inspector Jacqui Gillespie, who is our subject matter experts on vagrancy and live link. So between us all, we hope to be able to answer all of your questions. As I said, I'll keep these comments brief, as I know you do have questions, and I will focus primarily on the amendments, given that we give our evidence on the bill in full on the 10th of April. As we all know, arguably the most detailed part of the bill does relate to biometrics. Of the documentation provided to us in terms of biometrics, there were 6 bullet points in relation to those amendments. At a high level, we have no concerns and welcome those amendments, but there are just a couple of specific points I think it's relevant to cover. In terms of point 3 in those bullet points, which was around the extension of the grace period upon which we can apply to the Commissioner for the retention of biometrics for those under investigation not yet convicted, from 14 to 28 days is very welcome. That helps us in the operational environment where time is a pressure, people are a pressure, so to be able to have those 28 days instead of 14 to apply for that retention is very helpful, and in the interest of protecting victims in terms of giving us that time to make sure that those are retained for investigative purposes. In terms of point 4 and applications to the Biometrics Commissioner, we do welcome this amendment, but we would argue that the powers shouldn't be restricted to those who have been arrested or charged only, and that's in relation to that extension, but also include those reported for an offence. The DOJ have shared a policy paper on prescribed circumstances with PSNI, which we'll comment on and return to them. We also specifically welcome point 6, as that will assist us specify a date and time for persons to attend a police station to give their biometrics, as opposed to what is the present circumstance where they have a broad 7-day period upon which to present themselves. That's helpful to us, but I would argue it's also helpful to that individual, because we do have a restricted estate these days, and we do have restricted capacity in terms of when those facilities are open. So it's not in their benefits to turn up at a time when nobody's available to take their fingerprints and DNA. So that will help us enable us to manage them, but also manage our own finite resources and ensure that we capture that biometric that can be used, obviously, to help detect crime that they may have been involved in the past, but also crime they may be involved in the future. Where possible, we will be flexible. Our approach to this, and it is of course early days, is that we envisage something like a number of days a week, a month, whereby, or maybe a couple of days a week, where individuals can come at sort of a set time period. So there will be some flexibility, that we're not specific saying you must turn up at 9:58 in Musgrave Street. We will try to be flexible, understanding people's needs, but within the confines of what allows us to do our job in an effective and efficient manner. So that's those 6 points in summary, but I would remind the committee, as I did the last time, that our previous thoughts on the introduction of the IT changes we require to be able to meet the biometric provisions was, when we previously did it a number of years ago, £1 million. So that will obviously now be more than that, one would suspect, given just how everything gets more expensive. So I'd again remind the committee that that's not additional money that PSNI will receive, and just adds to the pressures that we have, that as much as we welcome changes in legislation, most of it comes with a financial tail, and this is just another example of that. In terms of the amendments in relation to restorative justice, we support the restorative justice practice as a principle. We absolutely don't want to criminalise people where we don't have to, particularly our young in society. So we support the broadening of agencies, the broadening of the scope of the number of agencies who can deliver restorative practices across Northern Ireland, and have been working closely with departmental colleagues in justice on this matter. In terms of the rehabilitation of offender periods, again, we support the reduction of rehabilitation periods, because we recognise that that does boost the chances of offenders gaining employment and therefore hopefully not re-entering the criminal justice system. And in turn, this supports the drive to reduce the number of victims, because if they don't re-enter the criminal justice system, there'll be less victims. And that, of course, aligns with our police and prime priority to be victim focused. In terms of the repeal of the Vagrancy Act, in relation to the repeal of Section 3 of the Vagrancy Act and Section 4, I have previously stated that the PSNI agree in principle with the DOJ position that we do not want to criminalise individuals for begging or rough sleeping, as they're colloquially referred to. Many of those individuals who we know have vulnerabilities and health needs. As I stated when we last were with the committee, a more system-wide approach is needed to address the underlying causation factors of homelessness and begging. This, of course, would be a positive alternative to criminalising those who are affected with these issues, and save the reliance on police officers having to use powers that don't, frankly, solve the issues in the long term. It just deals with the short-term challenge at hand. We do, however, have some concerns that some replacements may leave a gap, and are aware that the committee has heard evidence from others in that regard. But it is, of course, important to also state, for transparency, data from police systems indicates that the PSNI do not use these powers on a regular basis. In terms of simple begging, which is Section 3, PSNI have dealt with approximately 7,000 incidents since 2018. So that's approximately 1,000 a year. 700 incidents a year, 100 a year. In relation to Section 4, focuses on found on premises for unlawful purposes, which, as I mentioned, is often seen as rough sleeping. This has been used 15 times in the last 3 years. In the repeal of the simple begging offence to Section 3, this will mean that police officers will no longer have the ability to rely on legislation to address simple begging. Ultimately, this might mean, as it is no longer a crime, where there is no wider offending or threats, police officers will not attend these calls relating to begging, unless, of course, there are other aggravating factors or offences being committed, such as public order offences or harassment, for example. In a benchmarking exercise across the United Kingdom and Republic of Ireland, it is clear to see that alternative offences have been implemented and are being explored as replacements for this legislation. Whilst there is no present intelligence or information available to me in relation to so-called organised begging or an established link to serious and organised crime in Northern Ireland, it would be sensible to acknowledge that this, similar to other areas of policing, may become a factor at some point in the future, and in my view it would be prudent to be prepared. Legislation that has been used in other jurisdictions, such as the Section 5 of the Criminal Justice Public Order Act 2011, is used by An Garda Síochána in the Republic of Ireland. That in itself, in simple terms, is an offence not to direct or organise begging, and it outlines an offence to control or direct the actions of another person for the purposes of begging. So in simple terms, if I tell someone else to beg for the purposes of organised crime, that is a criminal offence. That may be a gap that we might want to ensure is closed by the introduction of such an amendment. Likewise, in England, the Crime and Policing Bill of England and Wales, Clause 11, is similar in terms of arranging or facilitating begging for gain. Again, very similar to what I have just mentioned. Both Section 5 in the Republic of Ireland and Clause 11 in England and Wales of these bills create a lower threshold we believe than what's required by the Human Trafficking and Exploitation Act of 2015 here in Northern Ireland. So in other words, we believe it's at a higher threshold. These are lower threshold offences that would allow us to have the powers to deal with such matters. Given neighbouring jurisdictions consider it prudent to introduce such offences, it may be unwise not to consider a similar legislative framework here, as displacement of offending from one jurisdiction to another is, of course, as we know, always a possibility. Likewise, with the repeal of Section 4, despite its low usage, as I've mentioned, it may be prudent to consider again other jurisdictions' alternative offences in respect of trespassing. In the Republic of Ireland, that's Section 11 again of the Republic of Ireland Public Order Act, which provides an offence to enter or be in any building as a trespasser, or to be in the vicinity of that building for the purposes of trespassing, or that proposed by Clause 10 of the Crime and Policing Bill of England and Wales, which is trespassing with intent to commit a criminal offence. These amendments, we believe, will ultimately ensure that there will be no significant gap with the repeal of vagrancy legislation in Northern Ireland. So in summary, in relation to the repeal of the Vagrancy Act, we do not want to see begging in its purest sense or rough sleeping seen criminalised. However, we also see this legislative change as an opportunity not only to achieve the objective set by the Minister and the Department in respect of decriminalising simple begging, but ensuring we modernise the law so it is fit for purpose in 2025 and beyond, and future-proofed in respect of emerging crime types and trends that is seen in other jurisdictions. We have passed these views on to the Department of Justice, who have advised they will consider them accordingly. In relation to the serious and crime amendments, largely around this, we believe brings an improved ability to disrupt serious and organised crime at an earlier stage, helping us reduce harms. Through the provisions that in the amendments, it strengthens our ability to apply bail restrictions and utilise disruption tactics. Crucially, it also improves our ability to target leadership due to the introduction of the directing offence, which has been a long-term challenge for us in the absence of that legislation. In terms of live links, the amendments that are made make no substantial change, so we support that. And I'm now happy to take your questions, Chair.
Okay, thank you, Anthony. Can I just run you through those figures again on the begging? I caught the trespassing one, which was 15 times in the last 3 years. What was the earlier one?
700 from 2018, so roughly 100 a year.
2018, so 100 per year. On that is the offence of
simple begging.
Simple begging.
Sense, yeah.
Okay, thanks for that clarification. It's just I didn't get the figure in the head and I didn't want to get it wrong. Can I just remind members that we're going to go on biometrics first? So if anybody has any questions on the biometrics pieces of the bill or the amendments, please notify us now. And don't worry, you will get time to ask questions on all other sections of the bill, either in this session or in the next session if it's required. Emma, I'm going to bring you in first, if that's okay.
Chair, and thank you all for coming in for the presentation. I wonder if you could outline what the current advice within PSNI is around detention or retention of data.
Data or biometric?
Biometrics, this data.
So presently, there is no local legislation in place on the retention of PACE biometrics. So what we do at the moment is that we revert to PACE, and PACE allows us to retain them indefinitely. So that is far from ideal from our point of view, and the fact that we, as you know, there are 2 European court rulings against the UK on this. One is SMR, and the other one is Gawker. And in both those, we would want to be able to comply with those, but unfortunately are unable because there is no local legislation, which is what the Justice Bill is all about, is getting us that legislation, which we're very grateful for. So we're obviously left in that position where there is no local legislation, yet at the same time we're in violation, if you like, of 2 European court rulings. So to mitigate that risk, we have in place what's called the Biometric Ratification Committee. And that committee meets on a regular basis, usually monthly, and individuals are able to write in and request us to review the further retention of their biometrics. Now, all the information on this is on the PSNI website. The information for the people, the means to do so, the application form, the reasons why we would retain, the reasons why we would delete, all of that is on there, and people do on a regular basis apply for us to review their applications, and very often we do delete them.
So further to that, that's an organisation within the PSNI again?
It's a committee within the organisation, yes.
So, in terms of a proposed review mechanism, would you agree that it should be a truly independent committee or organisation that are making that decision, so as that we don't have sort of the PSNI reviewing the PSNI?
Well, what we review against is a very, very clear set of standards. Now, there's a large group of people around, say a large group of people, but I'd say a diverse group of people around the table from within PSNI. There's myself as the head of biometrics, the head of scientific support, the head of the ID Bureau. We also have people there from our public protection unit. We have people there, we have our human rights lawyer, sits on that as well. And as I say, we have a very, very clear standard and set of rules that are set within the service instruction, which is published on the website, which says when we do delete and when we do retain, and that's what we that's what we apply the criteria against. That's what we assess against, and on the basis of that, we either retain or we delete. If someone is unhappy with the result, which we have given, now usually obviously that'll be that we're going to retain them, then there is an appeals process, and that goes to the ACC for the ACC to look at it, for them to make the decision on.
Okay, I just, because even at the outset of your answer, you referred to the fact that you are allowed to keep them indefinitely. So it's how it works in practice, I suppose. What we're trying, the difference that this is going to.
So PACE allows us to do that indefinitely at the moment. That's because there is no local legislation in place.
Yeah.
Whenever the new legislation comes into place, then at that point a completely different retention regime comes into place. The purpose of what we'll do here then, or say what we will do as in PSNI, we have a project which we've already stepped up, and that will then put a process into place where all of this is taken care with in terms of software, policies, procedures, everything else will be in place to do that. And on the day of commencement, if you like, we press a great big red button, and at that point there's a lot of fingerprints and DNA get deleted off the database, and then on an ongoing basis forward to that, then there will be a continual process of deletion as people reach their biometric retention date. And when they meet that, there will be deletion from those people off the database.
I think it's also important to mention, and you quite understandably asked the question or made the comment around marking your own homework. And that's what we would see the role of the Biometric Commissioner bringing value to that. So as Jeff has said, going forward, rather than this retention indefinitely, these set periods of 75, 50 and 25 years will allow that deletion. But as you'd be aware, there's also the provision that people can ask at an earlier stage, or the potential that people can ask at an earlier stage to have their biometrics reviewed. So that, yes, that will be something that the PSNI will continue to do, but if they're not happy with that, the decision, let's say we want to retain it, then the role of the Biometrics Commissioner, or part of the role of the Biometrics Commissioner will be, there can be an appeal mechanism to that individual as opposed to an ACC and police, and bringing that independent, if you wish, scrutiny to the entire process.
And if I can, Chair, as I understand it, the provisions within the bill would still allow for the Chief Constable to have oversight of it. Would you be opposed to a completely independent mechanism which sits outside the PSNI?
I'm pretty sure within the paper that was put forward by the Department of Justice there on the review process, that if the Chief Constable decides, so say someone is up for review, that they ask for their biometrics to be deleted, the Chief Constable believes that we shouldn't do that. They have the right to take that to the Biometric Commissioner. If the Biometric Commissioner says that we delete, then we delete.
Okay, so the Biometric Commissioner has power over what the...
At the review stage, yes. They will.
If there are lawful reasons to show that we have misapplied the law in relation to the retention or considerations.
Okay. Thank you.
Okay, before bringing Ciara, can I just stay on that point? What do you see the relationship being between the Chief Constable and the new Northern Ireland Commissioner for the Retention of Biometric Material? How do you see that interaction?
Yeah, I mean, we welcome it, clearly. I mean, there are commissioners in other areas of business. So, as I said, Chair, I think this brings some degree of independent scrutiny to that process. Will be that external check and balance for us to, and you know, frankly, if this is about public confidence and which is what we want to deliver within police, and that external and independent scrutiny is very much welcome. And that appeals process that we've just talked about, again, we welcome, you know, because if we do get it wrong, or we made errors, or there's learning to be taken, then we're a learning organisation, so we're very happy to have those engagements and dialogue as and when those circumstances arise.
Do you see in the legislation proposed the clear demarcation between Chief Constable's role and Commissioner's role?
I think it could do with clarification in the guidance, and we had a conversation with the department on this, just around that exact detail of that relationship, and exactly the question that the Deputy Chair asked there, just in relation to the decision maker authority piece. I think I'm not necessarily, it's a matter for yourselves and the Department of Justice. I guess for me it would either needs to be probably a little bit more clear in the legislation, but it could be dealt with by way of guidance. But certainly from the conversations from the Department of Justice, I'm content from what they've explained to me that it's a very workable arrangement.
Yeah. So the bill here will set out clear provision and responsibilities, duties for the Commissioner, because it's a new animal, if you like, and so statute dictates what the parameters are. But I suppose it's the connection between the current roles that the Chief Constable has, the amending roles that the bill will enact, and then that interaction between two people with regards to some of these decisions. Are you 100% sure who has the final say? Is it the Commissioner? Is it the Chief Constable?
I'd need to look at the legislation again. I've read it probably about 10 days ago, but now you've asked the question, I'm happy just to follow up. I certainly was in my head when I read it, when I last looked at it, but I'm happy to look at it again.
No problem. You want to come back?
Sorry, just on the point that you've just raised, Chair. So, because the Chief Constable must have regard to any guidance issued under paragraph 5, in which it says the Commissioner may issue guidance about. So it still looks as if the Chief Constable has oversight.
Yeah, I think we need to get it teased out. Just that part 6 may well be under other guidance, but within the duties that the Commissioner gets, we'll need to see it on a sheet as to the actual duties and roles. But I suppose if there's doubt at this stage, then I think we need to just iron it out. So I'm happy enough even that we get something back, just clear about the interaction and the roles and responsibilities and the duties of both. I'm going to bring in Ciara.
Thank you, Chair. I just have a few areas I want to follow up on. As you're well aware, there's been strong discussion, particularly with ourselves, that we believe the draft bill needs to incorporate the provision to deal with the retention of photographs. And there's been various conversations. Do you agree that a photograph becomes biometric once it's used for identification purposes? Particularly given that PSNI images are shared with the police national database on a continuous basis. So I'd like to have
so
your thoughts on
you
this.
remember whenever we were here in April, this was raised, and so we would, whilst at the moment the bill doesn't contain any mention of images, we've made the decision within PSNI that we will treat custody images as a biometric. In other words, that we will apply the retention rules that there are for fingerprints and DNA to the custody images. But so, in many ways what we're doing is following on from the ICO's recommendation, which would say that as soon as that image becomes templated, in other words, as soon as there is a biometrics matrix put on top of that, in other words, it can go onto a searchable database. As soon as that happens, then that becomes a biometric. So we would agree with that, and we will be applying, or we certainly intend to apply, the same biometric retention rules to our custody images as we do to our fingerprints and our DNA.
So you would agree that it should be incorporated into this bill, and the actual word photographs should be included within this bill?
Well, that's a matter
biometric material.
But that's how we're going to treat it. We're certainly going to treat it as a biometric, yes.
But it'll be operational, it'll not be statute.
Yes.
Okay. I suppose secondly, obviously we're conscious of public awareness of these changes, and the recommendation would be that the PSNI should consider how to increase public awareness of the proposed changes to the use retention of personal data and the potential procedures that they need to follow. Have you given consideration to that recommendation, especially in relation to under 18-year-olds, and likewise, particularly, I would be quite passionate about those young people with neurodiversity. So just any thoughts on that, or where you are with that?
Like in terms of whenever the legislation goes live?
Yeah.
Yes, to that there. So, what we will be intending to do is to retain the Biometric Ratification Committee. That will be retained whenever we go live with the legislation. So that will allow anybody to write in at any time to ask for a review of their biometrics. So that's going to stay. At the moment, all the information there is around that is already on the website. In terms of, and we do, as I said before, we get quite a few applications for that and we process them, and that certainly seems to have worked quite well. Moving forward, there probably is, yes, we'd say a communication piece for us to take on board before we do go live with this to make sure that everybody is aware of what is happening. But I think it is important to remember as well that whenever this does go live, the vast majority of the biometrics that come off will be coming off automatically. So because they will have reached their biometric retention date, you don't need to apply to have your biometrics deleted. They will be deleted automatically as soon as they reach that biometric retention date. Mm-hmm. So it will only be if you want your biometrics to be reviewed before that date comes that you would make a written application to us, and then we will consider that.
I suppose it's just to come in on that as well, but even in the initial stages, even if you're in a custody suite, and informing and educating the young people on what information you're taking, why you're taking it, where it's been held, how long it's been held for, being able to communicate that. Have you done any work on that? Is that currently available? Is that within your operating standards at this moment in time?
You mean within custody?
Yeah.
Are those issues? I'm not an expert in what happens in custody now, so I'll defer to my colleagues here as to how that works.
Yeah.
Sorry, that's not within my remit either, so I'm sorry I can't advise on anything custody because I don't work in that particular area.
Well, that's fine. Well, even if you can follow up, it would be useful just to see what's currently.
I think going forward, and I mentioned this as you recall the last time, so we're still quite a bit away here as well though, because we've just got the amendments, but I absolutely agree, and it's similar to any other pieces of legislation that we've introduced that are of a reasonable magnitude such as this. So that will require training of our staff, it will require communication strategy covering all the points that you will have. So we will have a process and structure in place that will do that. I would hope that would be in partnership with the department, not just the police, obviously, because it impacts across the piece. So yes, we will do that, but truthfully, I feel it's a little bit too early because we still haven't got the finalised legislation before we can really start making firm plans about what we're going to do.
Okay, just one final question. In Scotland, obviously, the current practice for under 18s is that only those arrested for violent or sexual offences or otherwise by exception have their biometric data taken. Have the PSNI a view on this practice, and would they have any concerns if such an approach was referenced in the draft bill?
I think it's like all of these things when it comes to age. You know, there will be polarised views on that across different sections of society. Ultimately, we'll apply the law as it's written. I don't want to stray into a view in relation to that from a PSNI point of view. I suppose what I would say is there's the Safeguarding Board for Northern Ireland, which is the legislated forum that looks after and protects the rights of children, of which PSNI are one such member. I would think that it might be prudent that the committee takes a view of that as a collective body on behalf of children.
Okay, thank you.
Okay, Morris?
Thank you, Chair. Thanks very much for your presentation. Apologies, I missed the start of it.
We're only on biometrics, just in case you missed that bit.
Yep. Just on biometrics. As a photographer, when I take an image digitally and I add metadata to it, I would presume in a PSNI context that metadata becomes biometric data, and therefore it should be included in any biometric profile. But what I would like to ask is, at the point of deletion from your biometrics, does that deletion happen across Europe, including the Irish Republic, which is part of the EU? Will it automatically delete across all platforms that you may have shared it?
So at the moment, the only biometric databases, if you like, that we share our images to are national to the UK. So they go into PND, the PND database, that's where they go. And yes, whenever we delete them from, or when we have a PSNI image, which is going to be deleted, then the messaging will go across to PND and they will be able to delete it from that database.
That's fair enough. The other thing that you mentioned in your presentation, I'll just touch upon it, as restorative justice, and you, for some reason, welcome a broadening of the organisations that can carry out restorative justice. Do you envisage sharing any biometric data with restorative justice organisations, and how do you plan to scrutinise those organisations and the people who are employed or are volunteers within those organisations?
So firstly, it's not the legislation, I don't believe, suggests that there's any sharing of biometric data with that, and I can't envisage any circumstances off the top of my head where we might want to do that out with this legislation or have any provisions to do so. to answer your first part of your question, in terms of the broadening of the restorative justice practice, the accreditation of that will be a responsibility for the Department of Justice. So we will work with the bodies that the Department of Justice have said are accredited and able to carry out restorative justice practices.
Yeah, you're right, it's not in the legislation, but these things have a habit of evolving into legislation as the bill progresses. Chair, that's me. Thank
Hey,
you.
Brian.
Okay, thank you, Chair. I mean, I'm by default wary of any new commissioners and offices. I just think we end up with more bureaucracy, and I think it's right that we question the value of creating another layer, another office, another expense in the public purse. In terms of what currently happens with biometric data, who oversees it? Are there officers with that specific responsibility, perhaps yourself, Anthony?
So Jeff has mentioned it again. We'll probably just chat you through it. So we have a biometric ratification committee that is responsible for the review of biometrics within our operational support department. That is led by, it's actually Assistant Chief Constable McNally Jones leads that department. But within that scientific support, who are responsible for biometrics, Jeff, of whom is the subject matter expert on that, are the body that are responsible for how the PSNI currently manages the retention of fingerprints and DNA and how we manage photographs.
Yeah. So you have a body that scrutinises this, oversees it, ensures that rules are enforced and applied.
Yeah, I mean, what we're doing at the moment is we're trying to, we just say, manage quite a difficult situation in that, we don't have any local legislation at the moment. So the way that we do that is that we apply the legislation that is live, which is PACE, but looking towards the 2 European Court judgments, which is why we have the ratification committee there, which allows people to say before they're, to actually write in, ask for us to adjudicate on that case, and in the certain circumstances, yes, we will delete their biometrics.
Yeah. So it's not too much of a small p political question. What difference would you see creating an ombuds or a commissioner's office would make, or would it make any difference? Do you think the same outcome could be achieved without creating that new office?
Well, I know there are 2 instances there that I'm aware of that we've received papers from recently from the department. Now, one has been on the issue of the review, so appeals for a review. So if someone has written in, asked for their biometrics to be reviewed, and the Chief Constable has decided that he wants to retain them, then at that point they can appeal to the Biometric Commissioner. There's also the issue of prescribed circumstances, in which it will be that will go to if you like, that information package that would be put together for that will go to the Biometric Commissioner, and it would be for them to then decide whether those prescribed circumstances should apply or not, and therefore that we would retain the biometrics for another 3 years. There may be other rules that the department have for that commissioner which we're not aware of at the moment, but those certainly would be 2 at the moment that we do know about.
Yeah. And
they provide that independent oversight of our decisions, which we would like to do.
Yeah. No, because currently the Chief Constable's, well, he may or may not be the final authority. I mean, you still have a policing board, you have a police ombudsman. I mean, but do you feel this would be a more obvious route for any appeal to follow if there was a commissioner then?
Yeah, well, I guess it is. It's certainly an independent eye on what we're doing, and not any retention that we're taking anyone who has an appeal or whatever. Then I would imagine that's where it will go to. So yes, it will be that, what you say, the independent person to oversee what the police are doing and their retention policies and how we're applying the legislation. And
I wasn't on the committee when we more detailed scrutiny this. So do similar posts exist in other jurisdictions?
There is a biometric and surveillance camera commissioner for England and Wales, yes. And I believe there's also a biometric commissioner for Scotland.
Okay. And the last question. I'm just trying to think of similar circumstances in which we have photographs, fingerprints taken, like a border control, at airports or at ports, mainly airports. Mm-hmm. Would that wouldn't come under this jurisdiction, or are there any controls that you're aware of regarding data that border control captures?
I'm honestly not sure exactly what's captured at the borders at all. Certainly that would be outside of the police's remit.
Our focus is on custody images. Images
Yeah.
will take
Yeah.
persons within custody.
But obviously, sometimes those images might be of interest to the police, you know, if they're trying to track movements, you know. But maybe that's purely for border control officers under the Home Office. I don't know.
Yeah, certainly we don't have any access that I'm aware of to any of those databases.
There is, just on that, and I could be wrong, but there is an exclusion for certain regimes, one being Schedule 8 of the Terrorism Act, 2000, International Criminal Court Act, 2001, Terrorism Prevention and Investigation Measures Act, and then also the Counter-Terrorism and Border Security Act, 2019, and it excludes those acts from Article 6.3b to 6.3x of this bill. Now, what that means, Brian, you'll have to delve into that yourself, but that's...
It's about retention. I'm just looking at it myself.
Yes.
It is about the retention.
Yeah.
No, and there's no doubt good reasons that, you know, records are not disposed of too readily.
Just on that point, because it is a very valid point, does that mean that material can be held as it is at the present time indefinitely?
Our images, as we say, as it stands, we are retaining our fingerprints
At the minute,
DNA.
But if wherever the images were obtained by any one of these 4 acts, how do you interlude with that? And do you use these acts, I presume, to retain or to arrest and then retain? How does
Those are all, I take it, counter-terrorist.
yeah,
For
mostly,
instance,
yeah.
so
International Criminal Court Act 2001.
So since the 31st of October 2013, PSNI has applied POFA, Protection of Freedom Act rules, to all TAC material. So we have been actively deleting material from that date as per POFA. So if material is taken under any of those or under the Terrorism Act or any other of the counter-terrorist legislation, then they will be deleted in accordance with the rules that there are within POFA.
Right, okay. Is that you finished, Brian? Thank you. Can I then bring you to the actual years, the periods? 75, 50, 25, 5, 3 and 2. There's actually this quirk whereby we have a length of service plus 5 years for if P is given a custodial sentence of less than 5 years and the offence is the first offence and is under 18. Why do you think there was that quirk made whereby it was the length of sentence imposed plus 5 years as opposed to the other nailed down periods of time, 75, 50, 25?
I don't have that in front of me here just at the minute now,
Yes.
but I would imagine, well, obviously they're a juvenile, so there's a different retention regime for juveniles than there would be for adults, so that would be the first. So there may have been someone that actually did the calculations on that potentially you could find that there was a discrepancy between the retention times that you have between 2 people. That's the only reason I can come up with, but as I say, I don't have that in front of me here at the moment.
Okay, the 2-year one is for P, if P is given a penalty notice under Section 660 of the Justice Act 2011. Now, correct me if I'm wrong, and I could be wrong, but that's basically things like criminal damage, drunk in a public place, where you would get a penalty fine. How do you then collect the data? How do you get the biometrics from that person if they've been given a fixed penalty notice?
Yeah. Good question, to which I simply don't know the answer.
Probably is that we don't.
Yeah.
And that's really why, whenever we go back to some of the previous questions there were around bringing people in post-conviction or possibly post-report,
Yep.
we should be able to scoop them up. Now, we have a problem at the moment in that we do have a lot of people. So, effectively, if you're not arrested, we have no way of taking your biometrics. And we have, within Part 4 of PACE, really strong restraints on the police as to when they can arrest and when they can't.
Yeah.
If you're not arrested, then we can't take somebody to custody. If we don't take you to custody, we can't get your fingerprints, we can't get your DNA, and we can't get your custody photograph. So the idea is, and why we would really like tightened up around what we can do post-conviction and post-report, is so that we can take those biometrics and get people on the database that have actually been convicted of an offence.
Yeah, retrospectively?
Yes.
Yeah, and I've seen that somewhere. I don't know where I've seen it. I've seen it somewhere.
It's within
maybe
PACE
PACE.
at the moment.
Yep, it's
yes,
PACE.
it is. It's possible within PACE at the moment, but you have to have the person has to be brought in a month after their date of conviction which is very, very difficult, and for the officer in charge might not even be aware that the person has been convicted. If the officer that has arrested them might not even be aware that they have been convicted on that. And then on top of that, they have a 7-day period of which that they can come within that month to give their biometrics. And of course, that's really difficult for the officer in charge. They could be on arrest day, they could be on leave, they could be in a different shift, they could be out on RTC or whatever has happened. And so basically, it simply isn't working at the moment.
Yep.
So really, what we would like to do is have that tightened up so that we can get them.
So you will then, through an amendment by the Justice Minister, have a power, if it's passed, if it's in scope and it's passed, a power to specify date of attendance at police station for fingerprinting.
Yes.
Must direct the person to attend the police station on a specific date, and must either direct the person to attend at a specific time on that date or direct the person to attend between specific times on that date. It's quite specific, but that's basically a mandate. What if somebody doesn't turn up? It's not an offence in its own right.
No. There is a power of arrest for the purposes of bringing them to the police station to take their fingerprints and DNA. It's not another offence that for failing to turn up for fingerprint and DNA offence, as I interpret it. So no, I don't believe that is a separate offence.
How much of flexibility will be afforded?
Yes, that's going to have to come down, Chair, to just sort of practical application of it, isn't it? You know, I mean, I would like to sit here and tell you that we can say to somebody that we've got a biometric and fingerprint clinic on Tuesday in Ballymena and Thursday in Musgrave, and it's between 10 and 2 in this one and 2 and 4 in the other. Pick which one and we can agree. Mm-hmm. That's the utopian world I'd like to get to. I don't know where we might be in 2 years, and it might be that we have to say we need you to turn up at 2 o'clock in Strand Road Police Station. You know, so I guess all of that will come down to our ability to apply flexibility within the budget envelope we have available to us, because again, this will require human resource to bring those people into the police station, into whatever environment that we're going to take the fingerprints and DNA. So I'd like to tell you we'll be as flexible as we can, but the reality will be dictated by the operational environment as and when this legislation comes to life.
Okay.
I think it's maybe
will that be administered? How will the person be notified? Will they be notified at the time when they get a fixed penalty notice, or would that be a letter summons?
The minute, how does it work at the minute, Jeff? I think it's the investigating officer is notified, so it'll be via the investigating officer, yeah.
And obviously there's a process involved there, because the investigating officer, by the length of time, sometimes things get to court. They could be retired, they could be transferred to another station. There's a whole different thing. So we're going to have to really sit down. This is one of the things we're going to have to do in the project, is actually operationalise this. Yeah. It's actually think how it works in practice. And that will be for the benefit of everybody. So it's obviously for the benefit of the individuals. So that, I mean, they're not coming up into a police station at maybe 11 o'clock at night when the place is either half empty or really, really busy or whatever way things are working. So we want to make this right for everybody. But the one thing I would say is this: our biometric databases will be as effective as they are complete. Mm-hmm. So we will be taking a lot of people off the database because we have to, and quite rightly that we do so. But we also want to make sure that we put the right people onto the database. And this is going to be one of our ways of actually doing that. And it is a gap that we have at the moment, and it's one that we'd like to plug.
So, Chair, just to finish, when I talked about the IT challenges, this is exactly one of those IT challenges around how, you know, so at the point of conviction to the point of sentencing, how then do we notify an investigating officer, and how do we notify an investigating officer that the biometrics have not already been taken? Because if they've been arrested, they will be. So there's going to have to be process maps and all of that work done in swim lanes to identify how do we get a process in place, an electronic process in place that notifies the officer and allows the officer and or to notify the individual to come to the police station. All of that work still has to be done.
Yeah.
That's what we have a project board in place to look at as and when the legislation is finalised.
Do you think that a fixed penalty notice should come under this biometric regime? Because at the minute, I suspect when somebody gets a fixed penalty notice, they don't get their fingerprints taken. So this is, if you like, is a further, you know, obviously we're in this place because of human rights compliance, but here is a further reach of you guys taking data of the person at a very low level. Now, don't get me wrong, very seriously, there's disorderly behaviour likely to cause a breach of the peace, but behaviour likely to cause a breach of the peace could be anything from parading to protest. So are we saying that we're going to take biometrics of those people who are protesting against the state?
Yeah, so as I mentioned, Chair, we have a project board that looks specifically at all of these provisions. I am not personally aware of what discussions there's been had around that, so I'm going to have to take that one off the table. I think it's a very fair question for you to ask, and I'd like to come back to you on that one.
Yeah, okay. And there's also, with regards to 2 years retention for penalty notice, there's no differentiation there between age, whereas in every other time frame, there is an age. Most of them, not the qualifying stuff, but the recordable stuff. There's the under 18 stuff, and right down to 25 years, and the length of service one plus 5 years. One other issue I have is that in the bill there's an amendment that's been split in two to allow a complete clause for restorative justice processes. Person completing a community-based restorative justice process. This surprised me too, in the fact that it says here that if the article applies where P has completed a community-based restorative justice process with respect to a recordable offence, if P was aged over 18 or over at the time of the offence, and the offence is a qualifying offence. So can you tell me under what circumstances would a qualifying offence be going through a restorative justice process? What would be deemed the most serious offences in this country? Why would they be going through a restorative justice process?
I think the restorative justice process is not for the most serious of offences, as we all know. But some of those offences will be recordable offences. So, for example, theft.
Yes.
For example, drugs possession will be recordable offences. But there may be circumstances within which a restorative justice approach is the right approach, because those are two particular offences that are, as we all know, ones where reoffending are particularly likely. So therefore, if that restorative justice practice stops that reoffending, well then I would be supportive of that. But those offences are recordable offences, so therefore there are offences by which ordinarily, if they were prosecuted, you would be seeking to take their fingerprints and DNA.
Mm-hmm. Yeah, but I suppose the question is, the question is not whether that person should have their biometrics taken. I think they should. The question is, how would someone that somebody aged 18, the offence is a qualifying offence, and their data will be retained for 75 years. There's no issue there with regards to that time frame. But it's the fact that this is included in a clause where P has completed a community-based restorative justice process. So my question is, what sort of qualifying offences actually go through a restorative justice process? Well, surely restorative justice is a very good tool to be used at a very low level, especially including youth, where there's a community-based solution. But where would a qualifying offence come into that?
Qualifying offence in terms of these provisions?
Yeah, so it's just basically a new clause. It's persons completing community-based restorative justice processes. Yeah. So it's a new amendment, and it's a new clause relating specifically to community-based restorative justice processes. But within that is contained the years, the 75 years for a qualifying offence, the 25 years for a recordable offence. So I suppose my question is, how would anybody that's been convicted of a qualifying offence be going through a community-based restorative justice process? It's not the retention of the data. It's about how could someone.
You're asking how somebody that has committed that level of offence can end up going through a restorative.
Yes, that's exactly what I'm asking.
But those level of offences are what I'm referring to, the likes of theft and possession of drugs type offences. Those are qualifying offences.
So they are qualifying offences. So they are deemed the most serious.
Well, they are serious offences. I mean, they're 14 years on indictment, they're classed as.
So suppose what I'm saying is, would there be a murderer ever go through a community-based restorative justice?
Not that I could ever foresee. No.
Right. Okay. Yeah. No, that's fine. Thank you for that clarification. Okay, I'm going to wrap up the biometrics piece unless anyone else wants to come in with a burning question. You did say, Anthony, that your people here, both Jeff and Jacqui, are efficient in the fragrancy legislation and the live links. Isn't that right?
That's Jacqui, not me.
That's Jacqui. So I do think we maybe should go there first, as opposed. So I'm going to take it out of sequence a wee bit, if that's okay. It's just while you're here and while we have the time. So I think we'll move to the use of live links and planned live links amendments. So if any members wish to ask questions around the live links piece of legislation, Emma, come on ahead.
Thank you, Chair, and thanks again. I suppose I want to ask about how live link interviews are governed and the confidentiality between client and solicitor specifically, and how you see that working.
Well, it will be governed in relation to the confidentiality, the same standard that our current interviews are governed at the moment. So it would be a secure live link, and the information, the data that's collated within that interaction would be kept securely. The actual, the live links interview is not recorded on the live link, it's recorded on the interview system. So at the minute, if we have an interview in custody, we have a recording deck and we have a CCTV and we have the equipment within that room to record the interview. The live link itself will be facilitated through WebEx. There will be no record. That WebEx interaction will not be recorded. It's simply a media. It's a means by which, if I am one of the interviewing officers and there's another interviewing officer in another station, it's a means by which all parties to the interview can see and hear everybody else and be seen and be heard by the other parties. So in effect, it's an interactive tool, the live links, but the data and everything that's recorded during that interview is retained exactly the same way as it is now.
Okay, and so that's an internal PSNI policy that manages that now? Or?
It's a national approach in terms of live links. So whenever the new amendments come in, that will be the approach that is taken. So there will be nothing recorded on the WebEx system itself or through the live links. The actual recording of the interview will take place as it does now.
Okay.
Have I answered your question? No. Because we're not currently doing this at the moment.
Yeah.
Because obviously it's going through as part of the bill. But when we do use this for interviews in custody, that is how it will work.
Yeah. And that's a secure system.
Yeah. It's as secure as any other system can be. Yeah. It's been subject to a risk assessment, and we're content the Chief Constable has signed that system off as being a secure system for the use of live links.
Okay. The Chief Constable has signed that off. Okay. And so then will there be engagement then with solicitors? And
yes, there will. Yeah.
So
all the partners that will be party to the live links interviews once they're up and running in custody will be engaged. In fact, we've already started engaging with solicitors. I think our custody team recently had conversations with them in terms of what this will look like, so that they are aware of it, and we will be doing a wider engagement once the bill reaches the end of its progress.
That's already happened, and they're content with it?
I wasn't party to the meeting, but I know it's already happened.
Okay, and in terms then of sharing of documents and the paperwork side of things, how? Okay,
so that will be shared through either somebody that has a secure email system. So at the moment, whenever we share data and information, documents with solicitors, it's done on a secure email address. It will be exactly the same if we share documents relating to a live links interview in custody. And if we're to share information and documents internally from, say for example, one interview team to another who's in a different location, that will be done through our secure internal email system.
Okay, the PSI.
Yes. Yeah.
Okay. Thank you.
Okay, Ciara?
So you're confirming live links currently has not and never been used here in the north at the minute?
Live links is currently being
in
used.
custody suites with yourselves?
Yeah, so it's used for...
Sorry, there are two distinct differences. So at the minute, part of these provisions allow for someone who has been charged with an offence to live link into a court virtually,
court, rather
than physically attend.
Yeah.
So that is presently happening. But as it stands, if we wish to interview someone, so if I want to interview someone from Musgrave Street Police Station who is the suspect is in Strand Road Police Station, for argument's sake, in Derry City and Strabane, we have no electronic facility to do that. It requires the physical presence of us all in the one location. Whereas part of these provisions now allow for me to sit in one location and the solicitor and their suspect to sit in a different location. So just for clarity, there's two different things for when we're addressing your question.
Custody, that is in custody, the interview's in custody, but we do have links through to the court at the moment.
Yeah. So just in your links to and to the court then, just obviously I'm assuring there's a quality assurance. How has it been going? You know, what data are you currently looking at? Are you been reflecting on how it's even working currently through the courts?
This has all been done. So this was brought in under the coronavirus legislation, as you'll recall. So this allowed us the ability to stop the movement of people. I mean, we very much welcome it from the point of view that it means that we don't have to transport someone and potentially police officers sit with them in a courtroom for 2 or 3 hours whilst we await them to be brought up for their particular hearing. So it allows us to do that remotely. I think it would be fair to say the facilities we have, nobody envisaged this back in 2020, so that the structure that we have for it has required a lot of modification in terms of us dedicating rooms and making sure that they're suitably away from any other environment for soundproofing and things like that, because judges have commented in the past about noise in the background and so on. So we have done a lot of work through our strategic custody group to try to make sure those facilities are as supportive for the judiciary, the police and the suspect and their solicitor as possible, to the point whereby when we built the Waterside Suite, which is our newest custody suite, it was very much designed with this in mind, and there was like a dedicated courtroom, if you want to call it that. It's almost like we just call it our virtual courtroom, whereby we'll bring that suspect as if they were literally sitting in front of the judge. So it's something we've been building on, and we continually refresh our custody estate to put these live link courtrooms in it. But that's, as you said, that's a very different thing than us interviewing a suspect remotely. So in terms of the live link purposes for court, it's working well. It's working well.
So I'm assuming then you're looking across your state
Yes.
and planning ahead in relation to ensuring that you have the adequate, obviously equipment, but the accommodation too. So it'd be useful to see where you as we progress.
Yeah. So we have
progress over the next year or two in relation to this legislation, obviously, because
so we have started that already. Right. An assessment of what equipment we'll need and the standards of the rooms, the interview rooms that will be required for whenever the legislation comes in that enables us to do that. And we've engaged our technical partners, and we've engaged a court service, and we've got costings. We've engaged a college so that they can begin to prepare an online training platform so that officers and staff will understand how to use the new process once it becomes enabled. And that is very much underway, and we've consulted across the organisation as well to take views in terms of people's approach on how they will use this new process whenever it comes in. So those views are currently being collated as well. So we're doing a bit of stakeholder engagement and looking at the equipment and costings for the rooms as well, and the training.
Okay, and I really appreciate that internal aspect that needs to happen. So I'm going to raise again, as I've raised in my previous, I have just one grave concern, and it's relation to specific groups of individuals and with developmental learning, cognitive differences, cultural barriers, including non-English speakers and stuff. So ensuring that the system works, but also the individual as well are well aware of how it's happening, why it's happening, the benefits of it, etc. Is there work being done on that? Maybe in contacting these groups and having discussions with them?
Once we get a little bit further on down the line in terms of making sure that we are really content with our internal process, we'll then start our engagement with the groups that you mentioned, and to get their feedback, because obviously that's important. And there are safeguards in the live link legislation as well in terms of vulnerable people under the age of 14, people between the ages of 14 and 18. So there's a number of safeguards already in the legislation. But I understand exactly what you're saying, because people need to know exactly what this process is, and they need to understand it as well. And they have to give their consent to be interviewed using a live links as a mediator, because if they don't consent, then the interview can't go ahead. But they need to make those informed consents.
Yeah.
So we're definitely
Just a red
doing
flag
that.
for me is just
Yeah.
trying to ensure those that are most vulnerable are supported and engaged in the process, and there is that opt-out clause whereby it just may not be suitable. I love face-to-face interaction, to be honest. I think that's best. So it would be quite daunting if you're in a custody suite and then you're on a link. And
Maybe just by way of reassurance, I echo your views, and I would take it further that it's not just about the interview, it's being in a custody environment, full stop,
yeah,
for someone with those particular concerns. So again, our Waterside suite was very much built with that in mind, a specific area for children and those with vulnerable people. We are in the very early stages of looking at an amalgamation of some of our other custody suites, so all of these things will be taken into consideration. We're in the process of developing a specific process and strategy stroke policy around how you deal with persons with neurodivergence. We've just developed a very specific how we support females who are in the custody environment, so we're very much alive to all of the different Section 75 needs beyond interviewing, but fully accept you.
oh no, thank you. That's good to hear. Thank you.
Okay, Morris.
Thank you very much, Chair. Just on clause 21, how many suitable custody suites do you have in operation at the moment? And you seem pretty confident there that the system is very robust. But would you commit to coming back here and telling us if there are any failures and how many failures that there has been? And the other thing is about the children. I'm not sure that live links should be the norm for children. I think it should be the exception. And when you talked there just a few seconds ago about even re-evaluating the current custody suites, that to me means you're going to reduce them in number, which means if you are you have to be taken to a custody suite to be interviewed by a live link, which in my area, which is the North Coast, means taking people from Ballycastle, Portrush, Portstewart, Coleraine to Strand Road or Antrim to be interviewed by live link. You're bypassing a large police station to get to Strand Road and to get to Antrim, and yet you're talking about reducing them even further. It doesn't make sense to me. Can you explain it a wee bit for me?
You're talking about the custody estate provision. I mean, I'll go back to the fact that we are a police service that this committee will know from commentary by the Chief Constable around what we would consider to be, when you factor in inflation, a significantly reduced budget. I guess we're no different in terms of when I think about the number of hospitals Northern Ireland had when I was a child versus the number of hospitals it has now. Custody is probably something similar within and police stations in general. We have a lot less police stations, so the cost of retaining custody suites is significant because they have to be to a very high specification, as you would expect, because quite often a lot of the people who are in a custody environment are in a state of crisis for one reason or another. So the cost of upkeeping 11 custody suites will far outweigh the cost of an old custody suites at that, some of which, things such as windows and opportunities for ligature damage and so on. So from a business point of view, would I like a custody suite in every police station? Yes, I would. But financially, is it viable? No, it's not. Does that impact on everyone, not just children? Yes, it does. But it's made with the best of intentions that the custody suites that we have are of the highest specification, that provide the best service for those who are there, be that a detainee, be that a solicitor, or be that a police officer or a police member of staff working there. So I understand your concerns, but from an operational perspective, it is the direction of travel, and I believe our only viable financial option.
Just one, Chair. You made reference there to the number of hospitals. There's a direct correlation between the reduction in the number of hospitals and the increase in waiting lists and the disservice within the health service. Are you not frightened that the same thing can happen to the PSNI, that it leads to long delays, a reduction in the proper service by reducing and reducing and reducing?
I think, and I fully accept the question. I suppose one way that I would look at that is in terms of police officers. Let's just talk about generally in terms of the police estate. I think what's probably the difference, so I'll not reference any other agency, is that police officers are equipped nowadays more so than they were 20 years ago to be mobile. Police officers can pretty much do everything they need to do whilst they're out on patrol. There's no real need for them to return to a station, and that's actually a great advantage. So therefore we can cover a broader geographical spread than we could have done, frankly, when I was an officer on the beat, when there was a requirement to return to stations. So I think from my perspective, the reduction in the estate is actually what was required and doesn't diminish our service. And in terms of custody specifically, we have had a challenge over the past couple of years in relation to Oma Station, which has been closed for refurb and has taken much longer than we have liked because we've uncovered broader problems than we've had. But we have looked at our response times, because to take your point, so if that means that officers are potentially and probably driving further to a custody suite, might that mean that there's a reduction in service to that community? Well, that's not tracking through. Our attendance at 999 and 101 calls has not diminished, despite the fact that we have at Oma Station closed and officers have had to drive to Strabane or another custody suite in that time period.
And you're not in my area enough. I'll leave it at that.
Ryan?
Yep. Thank you. Well, like others, I welcome this whole topic being taken out of coronavirus emergency legislation and putting on its own standing in the modern world. You know, using live links. We all still do that for some meetings, but equally, I think we're all glad to get back to face-to-face meetings. As Ciara has said, you know, face-to-face meetings, just the quality of communication, of understanding, is much greater compared to online meetings. So I'm looking at some of the responses, you know, from groups concerned that this would become the norm. So I get... Which
aspects are you referring to would become the norm?
Well, either live link interviews or matters relating to court proceedings. And looking at the conditions, a custody officer considers that the live link is appropriate. The arrested person has had advice from a solicitor and the appropriate consent's been given for a child. But there's nothing in the legislation which places any restriction on the growth of this. So in terms of the concern that this should not become the norm, that you have an officer sitting somewhere, and I obviously it'd be more time efficient. They can do lots of interviews or issue cautions or whatever over the internet, but ensuring that people have a clear understanding of what they're consenting to, get the proper advice, aren't feeling rushed or pressurised. It's hard to capture that in legislation.
Oh, absolutely.
So how do we ensure this doesn't become the norm on the grounds of efficiency? And normally I'm speaking for efficiency, but in this case I think we need to ensure people are not being pressurised.
And efficiency would not be the motivator for me to carry out an interview of someone who's in a different place than me, because I actually think, like yourself in that scenario, I would much prefer to carry out an interview face to face. I mean, I think, you know, again, operational practice, and we'll have to look at what our operational guidance is around this in due course. But I will never say never, but I would pretty much never say never would we ever be interviewing someone who is arrested for murder or rape with the police officers are not in the same locality as them, unless there are really extreme circumstances. And that might simply be that the officers can't get to that station within a time period because of weather, because of something really out there that would restrict it. So I don't see this. I see this being something that officers could use where there are, if maybe time pressures on the clock. So let's say, for example, the officers were with that individual, but they had to carry out an inquiry which caused them to go somewhere else and they can't get back in time or whatever, but there's a police station near and there might be circumstances like that. I think in truth, my assessment of it is I think it's a useful tool to have, but I don't see that operationally this will be the norm, it will be the exception. And that's certainly the discussions that we have had within the police.
Yeah. Okay, but something I'm sure we'll be able to. Would statistics, do you think, could they be produced so that the use of this could be tracked?
We did a benchmarking exercise with other police services, and there's very, very little use of these types of interviews in custody. And these services that we had the benchmarking interaction with have had this legislation since 2015. It's very rarely used, so we don't, as the boss said, envisage it being business as usual.
Okay, thank you.
Could I just, a wee quick one just?
Yeah.
With regards to the benchmarking that has been done since 2015 elsewhere, do they have review periods set in where they would review
They'd review the usage.
the usage of it?
I didn't ask that question. I mean, I can go back and ask if you want that information. We shared the results of the benchmarking exercise with DOJ colleagues, but I can certainly go back and ask them if that's the case.
Be useful, and
Yeah.
then what quality assurance system they
Yeah,
use
yeah.
for live links as well would be useful. Thank you, Jacqui.
Okay, Danny, remotely.
Thank you, Chair. And Chair, just because custodial settings have been mentioned here in some of the answers, I just wonder, could I stray a wee bit away from live links, but it's something similar, if that's okay?
Okay, it might be picked up in our agenda item, but is it?
Yeah. So I just wondered, a number of clauses in the Justice Bill provides legislative underpinning for the separation of children and adults in custodial settings on sentencing, remand and detention. Can you explain what steps the PSNI takes to ensure that that same standard is replicated in the custody settings?
I'm not following the question. The custody sentence?
Settings.
Oh, settings. Sorry, I thought you said
Yeah,
sentence.
sorry. The signal's not great, sorry.
Yeah, you wouldn't. You couldn't just repeat it for me, just so I'm answering the right question.
So within the Justice Bill, there is underpinning legislative that they want to do around separation of children and adults in custodial settings, on sentencing and remand detention. But just wondering, could you explain what steps the PSNI will take to ensure that the same standard is replicated in police custody settings?
As in where children are kept versus adults? Yeah, okay.
So, yeah.
So as I mentioned, that is something we're very much alive to. I've talked previously there about how we have taken the learning from previous experiences whereby we have built a specific section within Waterside custody suite for children so that they are separated from adults. There will be undoubtedly, well, firstly, what I would say is taking children into custody is absolutely a last resort. And getting children out of custody as quickly as possible is our absolute priority. So I should say that at the start. But where they are in custody, where it's at all possible, we will make sure that they're separated from adults. But there will be times, particularly in the smaller suites, and that's back to my point around modernising our estate and having better facilities, whereby that opportunity is diminished. But there will be times whereby children are on there are 5, 6, 7 cells in a row, and a child might be in one and might be adults on the other side of it. But that's where we try to avoid those circumstances where at all possible. So we're very alive to the needs of the child. A child will obviously have the rights to an appropriate adult to support them through all of those processes, and there are particular guidance and instructions that we give to our custody officers and staff as to the needs of children, and we're very happy to share those with you if you feel that would be of help.
Okay.
No, that's brilliant. Thank you.
Okay, let me just see if I have any questions. With regards to the quality of connection for interviews, how have you found, so you don't do interviews at the minute through live links, you only do court hearings through the Coronavirus Act, is that correct?
Well, we do some that were as a result of the measures that we put in place as a result of COVID. So we do sometimes, not very often, do a voluntary interview.
Yeah.
Via live links.
Right, okay.
But that is not in a custody setting. Yeah. It's a voluntary interview.
Yes, okay.
When we first introduced this process, as I say, as a result of COVID, there were issues sometimes in certain areas where the connection wasn't great. Mm. But our ICS colleagues did a lot of work within those interview rooms to improve the connection. And as I understand it, the connection issues that we did experience are now very far and few between.
Well, obviously we understand the Coronavirus Act and the movement of people, and the meaning that you could basically be in a court setting remotely from a custody suite or a prison cell or establishment. But if we extend this out, what control will a defendant have to the actual live links? So who will actually control the feed or the link? And what's to stop somebody being questioned, it's probably the right terminology to use, from interrupting the feed, switching it off even?
The controls will be within the PSNI state, and if it's connected to the court, it will be within the court's estate.
Yeah.
So any interaction that we have with the courts is usually managed from their end. But in terms of interviews that we conduct, those controls are managed from our, our technology.
Right, okay. So somebody being questioned just couldn't turn off the link?
No.
And the interview cease?
No. No, I've never said never really, but they won't be, they won't be near, they won't have access to the controls in order to
So on a practical level, they will still be accompanied. It's not like they'll be sitting on their own. They'll still be accompanied and managed, obviously, for their welfare and security, and for the general run of it. So, as my colleague says, even if they were, for example, worst case scenario, to get up and break the screen or something like that, well, we'll use another screen, or we'll revert to doing the interview by way of a manual process. So, but
how does that affect custody clocks and stuff?
I suppose ultimately the ability to affect a custody clock is pretty limited from the point of view that will there be some delay? Yeah, of course there will, but that my thought process would be minimal, because you can still then, if for whatever reason the tech, let's say it's not sabotage, let's say the tech goes down, it's a stormy day or whatever, or we have some sort of catastrophe, then we'll just get another police officer in and carry out the interview. So there might be some delay, but ultimately that's on us to manage accordingly. Go ahead.
They're never on their own, so an interviewee will never be on their own interview. There'll always be another police officer.
Yeah, okay. And they're probably legal representative.
Yeah.
So there's a quirky clause in the amendments that the Minister's bringing forward, whereby a court or a tribunal must give a live link direction unless it is satisfied that it would be contrary to the interests of justice to do so, where a participant is a public authority or an officer or representative acting on behalf of a public authority, where it's a single participant proceeding. Now, public authority includes the PSNI and the constable, and, interestingly enough, the First Minister, Deputy First Minister and a Minister in the Executive. Why would you need that? What scenario should that be used for a police officer?
It may well be for their own personal protection.
Right, okay.
In terms of it's not prudent to move people about into public arenas in and out, so therefore it could potentially be for their own protection and safety, and the safety of those looking after them would be one such example.
And this is purely down to my ignorance. What is a single participant proceeding?
I interpreted that to be that it's them and them alone as a defendant. So it's not that there's co-defendants, so you would have someone else in a court and me in a different environment.
Right, okay. Thank you for that. Nobody else now on the live links. I think we've exhausted that. Thanks very much. So I'm going to then move on to the repeal of vagrancy. Vagrancy legislation, if that's okay. Anyone? Connie, come on ahead.
Thank you, Chair. I appreciate your coming in today and your presentation, especially that you agree in principle with the repeal of vagrancy. Is something I agree with as well. But very conscious, you'll be the ones that are operationalising this. And I think just Paul had asked around the statistics, and I think you'd said around 100 per year since 2017.
Mm-hmm.
Was that for begging? Sorry.
Yeah.
And then it was less than that for rough sleeping, was it?
We've never prosecuted anybody for rough sleeping.
Okay.
There's been 15 people
trespassing.
The trespass.
Trespassing. Sorry.
The section 4 is the trespass offence. So there's been 15 people charged with that over the last 3 years.
Okay, and I think what I really wanted to know was, especially for begging, is that then I was kind of wondering, is that the police intervening on a call out, or is that you going in arresting someone and then bringing charges?
So we can come across instances of begging in a number of ways. One will be a member of the public can report the matter and then we will respond, or a member of the public may report a matter and we respond and we come across an instance of begging, or it's come across whenever officers are on patrol.
Okay. And then, how do you intervene then?
Well, okay.
Obviously, given some of these individuals will be vulnerable, and just
for
information.
and absolutely, and I understand where you're coming from. So, we will only ever arrest for begging as an absolute last resort, whether it's nuisance or somebody is repeatedly begging in the same location after they've been asked to move several occasions, or people are feeling intimidated, or it reaches the threshold of maybe public order offence or a harassment offence.
Mm-hmm.
But in terms of the arrest, it's as a last resort, and we will be a little bit intrusive around the circumstances of the person that's begging, who they are, what the circumstances are, why they're begging, whether they have any particular needs. And we have broadly the same approach but slightly different in different areas, and we responded in that vein to the public consultation. So you'll see all the different areas within PSNI and how we respond to begging. But it's absolutely at a concern for the person's welfare and what other support they need, because we all know that people have, so many complex issues, and that can lead people to be on the streets begging. And even we know that sometimes even when people are given the support, they're still kept in that cycle of begging. So we're looking at, officers look at how they can signpost them, what help and assistance they need. But it's absolutely a last resort when people are arrested and put forward.
I think that's helpful as well with officers signposting them. And with those statistics, are you seeing them that you've given since 2017 with, it was trespass for intent and begging,
Mm-hmm.
Are you seeing them, are they increase every year since 2017, or have you seen a decrease year on year, or is it just roughly the same amount per year?
It's probably on average the same amount in terms of begging every year.
Yeah.
I don't see any notable increase, but I would have to go back and look at the figures again in terms of yearly figures rather than just giving you that ballpark figure.
No, I appreciate that.
And the numbers are small,
Yeah.
and that refers to the fact, as my colleague says, that it is used as a last resort. As I mentioned in my opening remarks, we don't want to criminalise individuals. We do recognise that they have acute needs and often seek to get them into sheltered accommodation and all of those things, which is what officers I see do on a weekly basis to avoid this as a last resort. We're very much a support service, but there will be circumstances where they're disruptive in terms of constantly outside the same shop and things like that, and shopkeepers are getting frustrated and so on. But it is, as you can see by the stats, something we don't want to do. But as I mentioned, we just would have that broader concern that without anything in replace of it, there just might be a gap.
Yeah, and then in terms of the section 4, the being found on premises for an unlawful purpose, that offence is very often added by PPS whenever a person has been arrested for other offences, such as, for example, burglary, and there isn't enough evidence to prove the offence of burglary, but the PPS believe that that actual offence of being found on premises for unlawful purpose has been made out. So they will, it's used by the Public Prosecution Service quite regularly.
I think I don't know if I could get another one, please, Chair. I think I am very broadly supportive personally of the repeal, and I think the principle, as Anthony said, I think is important here, and we're dealing with more so often very vulnerable individuals, and obviously we have a few hoops to jump through in this assembly to get, if it gets to the assembly floor, and then it has to be passed for this to go through. But I think, just conscious of the things you've said around slight concerns around a few gaps, do you think it would be helpful if it does go through, and following that there would be engagement with the department and reviews to just identify any gaps to make sure they can be properly addressed?
Yeah, absolutely. We have engaged with the department throughout all of this, and we certainly welcome that going forward to continue, because I know the committee have proposed a few questions for us to consider, and I've had a look at those, and considering that neighbouring jurisdictions have seen fit to introduce legislation to plug any gap, I think it would be prudent for those to be considered here.
No, I think that's helpful, and I think when it comes to tackling some of these social issues, we do need a more rounded approach rather than a justice one with the PSNI alone. So thank you very much. Thanks.
Thank you, Connie. Brian?
Thank you. I have a lot of interest in this section. I am concerned about the public message. If messaging, if the message goes out like rough sleeping and begging is no longer an offence, and I get entirely that the solution is not policing. You can't arrest your way out of where nuisance is caused, and I get entirely there are issues of mental health, addiction, at play, and the need for support services, and all homeless charities are committed to a accommodation first model and bringing support to people. But my concern is that the police have sufficient tools. I've had meetings at their disposal. I've had meetings with traders in the city centre. Alistair Hagan was at a meeting recently. He was highlighting how currently the PSNI, compared to forces in GB, a range of powers that do not exist here. Public order protection, public space protection order. That's right. So what's it again?
Public space
protection order. Yeah, and sufficient move on powers. And if it's left that the police have to, an offence has to occur before there could be intervention. As opposed to where people are reporting feeling harassed, intimidated. And I do speak to people when they go through the city centre that particularly women, I think are more likely to come under harassment and aggressive begging and feel threatened and not feel safe. And we have had incidents of physical altercations, which have occurred. So we did get a letter in our pack this week from the departmental officer saying that actually Section 4 of the 1824 Act is largely redundant anyway. It's been superseded. Apart from this issue of found on premises for unlawful purpose of trespass, so that's the question about trespass with intent about that. And also, I don't know if you've seen Professor Kevin Brown's paper to us.
Yeah.
And when I read through that, I think that is helpful, and we had him out giving evidence to us to address begging, causing harassment, obstruction, or public order concerns. And it's all right for us sitting here saying, well, we don't want to be interfering with people who are vulnerable. But if you're trying to run a business in the city centre and customers are being put off coming in because of someone's inappropriate behaviour, or you're somebody who's questioning whether or not you'll go in to a retail area such as the city centre because you think you're going to get harassment and not feel safe, we have to ensure that the police are able to intervene, to move people on, to discourage inappropriate behaviour. So I was keen that to hear from yourselves about your opinion on Professor Brown's amendment and other powers which you feel you might find yourselves lacking or do currently find yourselves lacking.
I had a call actually from Retail and I just this morning expressing exactly those concerns. So I've had a look at Professor Brown's paper and I do agree it's helpful. It sets out various bits of legislation that can be considered, and also his recommendations in terms of other legislation that might be considered to be introduced here. So if I just take them one at a time. So you mentioned the offence of trespass with intent, and as we've already heard, that was used, 15 people were charged over the last 3 years with that. 12 of those people had that offence added by public prosecution service whenever the PPS were reviewing the file, and it would have been in addition to other offences that were on the file. And as I said earlier, it's usually used if the offence of burglary can't be made out. So Prior to that, I had a look just at the years prior to that as well. So between 2019 and 2021, 8 people were convicted of that offence, and all of those people that were convicted of that offence had had that offence added by the Public Prosecution Service at the decision-making stage of the case. And usually it was, again, when the offence of burglary couldn't be made out. There was one occasion somebody trespassing in a front garden, urinating. Another occasion, somebody had been on what was described as a crime scene and was found in somebody's shed. And another person had gone into a new build and the owner wasn't there. When they came back, they found them asleep. To prove the intent required for burglary wasn't made out. So it is an offence that's applied. It's not used very often, but it is applied. It's still being considered by the PPS. So one of the questions that were asked was what concerns might there be if this is removed and how might it otherwise be captured? Well, there isn't an alternative as far as I know, and I've researched this, an alternative standalone offence of trespass with intent. And as you'll see in Professor Brown's paper, I don't want to repeat that, I'm conscious of time, but there are a number of specific offences that have intent to do something else. So the burglary's intent to steal or commit grievous bodily harm or to commit criminal damage or having entered, do any of those things. There's a trespass with a firearm with intent. There's a number of offences that relate to intent. However, there's no standalone one. So there's no broad one. So if that was removed, then those offences that are being captured at the moment, where there's not enough to prove a specific alternative offence, would not be captured. So that is what would happen. And in terms of how can it otherwise be captured, the ACC has already mentioned the Section 11 of the Criminal Justice Public Order Act 1994 that's used by the guards down south, and that provides an offence to enter or be in any building or its curtilage as a trespasser, or to be in the vicinity of that building or curtilage for the purposes of trespassing. It's quite a wordy offence. Or alternatively, a very similar measure that's being proposed at the minute in England and Wales, which is Clause 10 of the Crime and Policing Bill, trespassing with intent to commit a criminal offence. So there are 2 alternative offences that we could consider for replacement.
Can you send those to us then?
Yes, indeed.
Yep.
Yeah, I can send them to you. Yeah.
Professor Brown actually alludes to the clause 10, I think, in his paper.
So are they referenced there? Right.
In terms of the move on offence, I suppose we need to understand from the committee and the Department of Justice what exactly you wanted from police there, because you can have a power to move on, but move on for to where, for how long. I understand in its simplest sense that may be useful, but the practical application of that would be something that would need to be thought through by yourselves and the department before we could operationalise such an offence.
Okay, Brian?
Yes, that's fine for now. And public space public space protection orders.
They're in place in England and Wales. Under the antisocial behaviour legislation, so I can remember, and that enables local authorities to put certain conditions on a public space. So, for example, no begging, and that has been used in England and Wales for that. But it's not just solely relating to the act of begging; it can be relating to a number of other things that people might consider antisocial behaviour within a specific boundary of a public space, and that is within the power of the local authorities rather than the police.
Right.
Including protest? Probably.
Yeah, I need to double check that.
Yeah.
Well, there's specific legislation governing protest in relation to duration, place, time, and so on. So there is specific legislation covering that. I guess it's more antisocial behaviour type activity than pure protest.
Okay. You, Brian?
Okay, yeah.
Morris?
Thank you, Chair. And the 2 questions that I had have been answered to Connie and answered to Brian and answered very well. Thank you very much. But I'm sure you've gathered I'm not a fan of centralisation, should it be local government, health or the PSNI. Not a fan. So, and I'm not against the repeal of this Vacancy Act. Actually, I think it's a good thing if managed properly. One thing I will ask is, will you come back with a post-implementation report on how well it has worked or how well it hasn't worked. Because we all come out with these great schemes that are designed to save money and save staff, but nobody ever revisits them to say, well, actually, this didn't work.
Yeah. It's like any legislation, you know, I mean, having been involved in many pieces of it now, and I think of the Domestic Abuse Act, the Stalking Act, non-fatal strangulation, all those offences, I very much welcome the opportunity to revisit them, because there's no doubt some have worked better than others and there are operational challenges, so the opportunity to revisit those are always welcome, and happy to provide the committee with whatever you desire.
Thank you very much.
Okay,
Chair.
Ciara?
I'm just going to repeat myself like last week. I think we need to be clear and differentiate between vulnerable homeless people and those that are begging against what is happening in relation to retail NI and the various reports where there can be a clear difference. So I just want to reiterate that. And it is antiquated legislation. We agree it needs to change. And I'm very supportive of the police approach to this, where it's not about criminalising a vulnerable person. And we can see very much the small amount of incidents that have been occurring, and likewise when you've done further work where you can't get an offence on burglary or for something, you then use this offence for these small numbers. So we can very much see when you're talking about quality assurance, you have been implementing a clear person-centred approach to this and the vulnerability, so I very much welcome that. I might slightly veer off, but there is some excellent work being done, and particularly in Belfast through the complex lives. And I know I've been involved heavily in Derry in relation to the city centre initiative with the police, with retail. Is that something from it's just a yes or no, something from the police perspective that you see the benefits of and that you would appreciate, which would assist you, but also support the most vulnerable, those type of projects being invested in?
Yeah, absolutely. It's getting the balance right, isn't it, between the vulnerabilities and the needs of people today on our streets, and, you know, the protection of others going about their daily business. It's getting that balance right, not criminalising those in need, but obviously being able to uphold the law in terms of citizens going about their daily business. It's getting the balance right, and you know, protecting the interests of the business community, that they can, you know, continue their business without any obstruction or irritation, or not, you know, any harassment or people being put off going to the shops. But we definitely...
But there's a clear line, and of course our retail workers must be protected, but that's not necessarily homeless people and people that are begging. So I just feel uncomfortable when the conversation veers into the experiences of our retail staff, which should not be happening. Of course it shouldn't be happening. And if there's offence against someone and someone feeling uncomfortable, the general public need to be protected. But at the same time, when it comes to vagrancy and homelessness and vulnerable people that are begging, that is quite different. And as people, as even last week, as retail and I had mentioned, the majority of people that is causing the issues are those that are living in the community
and I'm sure
and are not homeless people, and are not those that are vulnerable and begging, because our retail staff are quite supportive of those people and actually support them and connect them to community groups and stuff. So it's just being so there's a clear delineation between vagrancy law, who we're dealing with here, and separately.
And there is.
I just want to reiterate the point, to be honest.
I can understand. You mean there are many different circumstances around that. You know, I mean, you take the protest, counter protest, different views, and all of those things. So there's lots of different legislation that we will use in those spheres, and then there could simply be, as you say, someone who has an umbrage against a certain individual. That's clearly, you know, that's not in the unlawful trespass space, that's into the harassment stalking space. So we will be alive to the different suite of legislation that we'll use in the most appropriate manner. But absolutely these offences are reserved for those who are very clearly not doing that with that intent.
Yeah, thanks. And if I can just make it clear that the retail subject came up because of the question that Brian asked, but it's about getting the balance right for everybody in society, not just retail people, not just people going about their daily business and, you know, regular citizens. It's about getting it right for everybody and making sure that vulnerable people get the support they need to stop the cycle that they're in terms of begging and homelessness.
And you do welcome the likes of complex lives and what the role that has to play and the interagency work that happens to support those that are most vulnerable.
Yeah.
Okay.
Okay.
I mean, the Glasgow Police Scotland have a multi-agency approach to homelessness and begging and rough sleeping, and you know that involves lots of statutory agencies and voluntary agencies and the police as well. So that I know that works quite well. So.
Okay, Emma.
Yeah.
Thanks, Chair, and thanks again for this round. I think Ciara has covered it, and that's the point. I wasn't going to come in on this, and to be honest with you, I'm catching up on all of this because I'm just newly onto the committee, but I think if I understand it correctly, the objective of removing this old outdated legislation is to try and get us away from language that was unhelpful and harmful, and a sort of means of policing that belongs to a day long gone and should stay there. And I'm not comfortable, sort of in line with what Ciara has said there around, it's almost nearly like the gentrification concept where, you know, this is a nice area and, you know, professional people are here or whatever, and we shouldn't have. So we need to have that clear differentiation between vulnerable people and somebody who's actually out to make mischief and how they're handled. And I would have concerns around even, and I understand that, you know, with the best will in the world, if you're, you know, the note that came from Professor Brown around advising people that they will be arrested. Well, if you're dealing with somebody who's very vulnerable, you know, how effective is that? So I understand it. I think that there was a note in the pack that has went to the Minister for comment, and we're awaiting her response on that. So I suppose it's just to have that clearly outlined. I don't know what the right answer is here, but we need to have a process that is compassionate and meets people where they're at.
Okay, and it's very clear with your presentation that you were very compassionate about the social issues that lead to people being homeless, sleeping rough, and then begging. But I also get a sense that you were very strong, that you were concerned about the gaps. If you were a business owner or a homeowner and you walked into your business one morning or into your house one evening and someone was standing there trespassing, vulnerable or not, what action can be taken if these laws are repealed?
Depends what the circumstances are surrounding that. I mean, if somebody is in need and they contact the police, they'll make an assessment of deployment of officers to wherever that person is at the time. So it depends upon the other circumstances that's surrounding that. You know, I mean, first of all, you would think, obviously, be alarmed if you came into your home and found somebody there that shouldn't be there. And I would imagine that that's something that we would have to consider.
So when you get that call and you end up going to the scene, what action can you legally take at the minute? What acts do you use to actually perform your policing role? What barriers do you have?
It depends it depends what the circumstances. So you could arrest that person. You would make
arrest them under what though?
On suspicion of burglary, or you could even arrest them under the suspicion of trespassing within, you know, for an unlawful purpose. Section 4 of it. We could use that at the moment. But what we do first of all, we assess the circumstances. You know, find out what's happening. But it's available to us at the moment, and if it was taken away, then it wouldn't be available to us.
Can I ask, are police currently trained in how to cope with people with autism and different complex needs?
We should be. That's the aim. We do try to train officers and staff to recognise those signs. Yeah. So
does that happen across the board, or is it?
It's part of our training programme for officers and staff within PSNI, and it would be part of our continual professional development programme. So as society learns more about these things, then it gets built into our training as well. So that would be a consideration in an officer's mind that's attending a scene, if that's... Yeah,
because sometimes for somebody in that situation, even the presence that reinforces a fear that they have that that they're bad or whatever. So
there is a suite of training. I mean, there's officers will throughout their life cycle. Obviously, the initial training that I would receive would be very different from what it looks like today. So there are continually suites of training added. So we have at the minute training around neurodivergence, training around complex needs. Adverse childhood experiences is trained to officers. we use the have used the GAIN guidelines for those who have, to use a broader term, mental health concerns. So there's a whole suite of options that we will use to help officers make an assessment of that person's particular needs. So in the circumstances the Chair laid out, again, I would reiterate, arrest is the last resort.
Yeah, of course.
We will look to look at that person's individual needs, but clearly that those are within the suite of options.
You would be arresting under what could be this vagrancy?
Could be, yes.
So
but bear in mind the numbers, Chair. They are minimal.
So I'll ask that question then. So out of the 100 per year for the begging offence, simple begging, which I think we all agree that the language in the old acts is horrible and needs reformed, and then the 15 times in the last 3 years for trespassing. What would you do 100 times per year, 15 times in the last 3 years, if these two pieces of legislation weren't in place?
Yeah, so that's that's the point that we're suggesting, and that we do think we might need to look at, particularly around a replacement for the dwelling type offence. So I guess it will literally be that down to that police officer's skills and ability to deal with those instances that will create some challenges, I suspect, in the small number of circumstances upon which we have defaulted to an arrest. But that's why we're keen that we don't repeal this without any further thought on additional provisions, and we're asking the department to consider, are we content collectively that the gap is not one that we're not able to operationally fill?
Yeah, that's very loud and clear. I think the committee has heard that too. Danny wants to come in.
Yeah, Chair, it's just a follow on from the Deputy Chair was asking around training, and I was just wondering around the use of spit and bite guards, particularly around children. And children's rights advocates have highlighted that the presumption that will not be used on children in the PSNI's guidance is very vague and leaves scope for routine use. Is that the case?
The case of its routine use is no, it's not routinely used, and again, all the considerations of the individual circumstances of each person will be taken into account before a spit and bite guard or spit and it would be deployed. In terms of the stats, that sits with my colleagues in operational support department. It's not obviously part of this bill, so it's not something I looked at before I came here today. So again, Danny, if you wanted the stats on that in terms of adults versus children, my colleagues in operational support department could supply you with that.
And I don't want to veer into the part 2 of this bill, which is children, because I do think we'll need this other session because we just have run out of time, Danny.
Yeah. No, sorry, and I didn't mean that it was routinely used. It's just that has been what's been said by children's rights advocates, that they think that the guidance is very vague and could leave it open to that interpretation.
Yeah.
Thank you.
Can I ask, just before we wrap up, and we will wrap up now, Anthony, we thank you for your time, but we aren't going to get through all these parts today, so we will have you back on the 15th of January, if that's okay, and you can decide who your team is with regards to the other various bits of the bill that we still have to cover. One question you did say about organised crime begging, and you did say there might be a gap there also. Do you have any evidence that there's an organised crime element to begging and that there's people coerced to beg?
So in the short answer is no. I have asked my organised crime colleagues within policing, have they any information or intelligence that would suggest that is presently happening in Northern Ireland, and the answer is no. But that's not to say it isn't happening and we don't know about it, or it's not to say that it may happen in the future. And as it now is an offence in the Republic of Ireland, is there an opportunity that may be exploited, that it comes north of the border? So we simply highlighted to the committee as part of their consideration.
And when you say organised crime, that can also mean paramilitary?
Organised, yeah.
Yeah. You talk about begging for gain. That wording sounds weird to me, because if you beg and you obtain money, you're gaining. That shouldn't necessarily be a crime. to gain out of begging?
It's in the context of you're looking in an organised crime type context.
Right, okay.
You're looking to fund something potentially nefarious. So it's not it's for gain for.
Yeah, I think that's in fact I know that's a proposed offence in the Crime and Policing Bill for England and Wales, Clause 11, arranging or facilitating begging for gain. So actually, if that's passed, will afford protections to people that are somebody comes along and organises vulnerable people and begs and then lives off the money that they get. That will give real strong protections to the people who are being exploited. And I think that's where that begging for gain comes from.
And that's the key. So the person who's gaining is not the person who's doing the begging.
Yeah.
They're the person being exploited, probably because of their vulnerability. Yeah. So that is why, why would you have that as an offence? It's because you're exploiting someone for your gain, not theirs.
And that offence is quite low level in terms of proving that somebody is being exploited, and it can include just transporting somebody from one location to another as part of an organised crime group, or even a low level one to facilitate that person's begging and then live off that.
Okay, and with regards to the question I asked you about, if you come home and somebody's in your living room or in your business or at the front step of your business, the actual begging causing harassment, obstruction and public order concerns, that sounds pretty neat to me. And that's Professor Kevin Brown's amendment, the one he's been good enough to actually lay out for us. Do you see anything in Professor Kevin Brown's proposed amendment that would cause you alarm?
I've had a look at it and I don't see anything. I don't know, so if you do.
Again, it would need to understand the department's view on it in terms of the specifics of the legislation and what it was designed to achieve, because I think the department, and I would say that I'm not saying that in and of itself as an offence would it be helpful. I think the simple answer is, can you see merits of that offence? Yes, but you have to ask yourself, what's the gap you're trying to fill? Yeah. And that's the bit for me. So there are other offences that would cover some of those aspects. So for example, disorderly behaviour, provocative conduct, those types. So there are a suite of other offences. So I guess we just need to understand what exactly the gap is you're seeking to fill by such an offence, and is there not enough already there? That's the bit for me we just need to understand.
Sorry, go on ahead.
Sorry, could I just clarify something? So in Professor Brown's proposed new provision, begging, causing harassment, obstruction or public order concerns, it's broken down into 4 parts, and the first one talks about those 3 things that we've just said: harassment, obstruction or public order concerns. The second one appears to be a standalone offence, standalone power, where a constable may direct a person who's begging near an entrance to a dwelling, an automated teller machine, cash dispenser, a vending machine or a night safe to desist and leave. So that's separate from the first part.
That's a power to move on, basically.
Yeah.
So would you welcome that power to move on, because you wouldn't be arresting someone?
Yeah, I think we need to be clear about what it is the role of the police is in around this space, because, as Ms McNally said, if, as a police officer, I ask somebody to move on and they move on, and then I get back into the car and I drive off to the next call, and then they come back in 10 minutes, what's the consequence for that? And what's the effect of me asking to them move on? Is it, will it have the effect that I intend it to, or am I going to be coming backwards and forwards for the rest of the day, moving this person on? Now, within Professor Brown's proposal, he says, if people don't move on, they commit an offence. Well, they don't move on and don't stay away for how long, for example. There's a lot of detail that perhaps would need to iron out if the department feel that we should have this power.
Karen, summary on that. I think for me the 2 questions that I would ask the committee to consider are, what are the gaps that you're trying to fill, and then operationally, how would you see this working, because of the very concerns we've highlighted. So we'd probably need a little bit more information before we could really give you an informed answer.
Well, I appreciate that. Thank you very much. Listen, I know this has been a marathon session for you, and we're only not even halfway through the bill, because it's a massive bill. But the next time we do meet, which hopefully will be the 15th of January, part 2 is children. Part 4 is administration of justice, and Part 5 final provisions. We have planned amendments for access NI filtering, restorative justice, rehabilitation of offenders and serious organised crime, and then of course there'll be private members' amendments. some have already hit the floor, so there'll be more, I suspect, by that stage. So, we probably will need another session similar to this, is what I'm trying to say.
Fine. We're happy to
It's
help.
okay.
Yes.
Okay, thank you very much for your time then. Thank you.
The BBC. No, Chair, if you've seen that. It's the headline on the BBC. I don't know if you wanted to mention that. 3 o'clock in the morning. There he's been. This morning, 2 o'clock this morning.
No, I'm not saying.
Chairs. Why did they put chairs on the wheels on? I never understand that. Thank you. Bye bye.
Chairs, you can shuffle your backside.
Yeah.
Okay, folks, we're going to move on. I know we have been pushed for time, members. Can I just stress that if we can, with this next session, if we can keep our commentary and our opinions to a limit and just ask questions, that would be gratefully received by us here to try and get managing this committee. Agenda item number 5 then is sentencing bill, pre-legislative scrutiny, Department of Justice oral evidence. Can I refer members to pages 147 to 166 of the meeting pack for the relevant papers? Can I inform members that the committee has now received oral evidence from Department of Justice officials as part of the committee's pre-introductory scrutiny of the forthcoming sentencing bill? As members will have seen in their papers, the sentencing bill is expected to be introduced early next year. The witnesses providing evidence today are Andrew Dawson, Director of Criminal Justice Policy and Legislative Division, Access to Justice Directorate; Angela Bell, Sentencing Bill Manager, Access to Justice Directorate; Máire Sheehan, Legal and Legislative Support, Access to Justice Directorate; and Michael McAvoy, Director of Community Safety Division, Safer Communities Directive. You're all very welcome to the committee as always. And Andrew, do you want to make an opening statement?
I'll make a quick opening statement if I can. As you have our written briefing of the 18th of November, I'll be brief on the background of the development of the bill and also just a very brief overview of the planned provisions. So the sentencing policy review was launched back in 2016 by the then Justice Minister Claire Sugden, and that was to consider the legislative framework for certain categories of crime, the setting of tariffs for murder, the arrangements for unduly lenient sentences, the effectiveness of community sentences and how these could be further utilised, and the effectiveness of the current sentencing guidelines mechanisms. The overarching aim of that review was to enhance public confidence, consistency and transparency in sentencing. The recommendations arising from the review were subject to public consultation in late 2019, and the Department subsequently published its analysis of the responses received, and that was in September 2020. Having reflected on the responses received to the consultation, the Department published its proposed way forward in April 2021. Executive approval to draft the bill was received in December 2024, and we anticipate that it will be introduced to the Assembly in early 2026. The bill will include provisions as follows. Firstly, a statement of the principles and purposes of sentencing for adult offenders to which the court will be required to have regard. The principles in the bill to be introduced will be proportionality, fairness and transparency. The purposes will be punishment, protection of the public including victims of crime, deterrence, rehabilitation and reparation. The bill will also provide for a new offence of assaulting a person providing services to the public, performing a public duty or providing a public service. This will seek to address increasing levels of aggression being displayed against a wide range of workers and will deal with assaults equivalent to common assault. It is also intended that the bill will provide that the fact that the victim is such a worker will become a statutory aggravating factor where a range of more serious offences are committed. The bill makes provision in respect of unduly lenient sentences. At present, where a sentence in certain Crown Court cases is considered to be unduly lenient, the Director of Public Prosecutions may refer to the Court of Appeal for review. The Court of Appeal has the power to order a different sentence if it considers that the original sentence was unduly lenient. The offences to which this relates are at the moment somewhat of a patchwork. Therefore, the bill will simplify and expand the unduly lenient sentencing arrangements so that any sentence imposed in the Crown Court will be capable of being referred to the Court of Appeal as being unduly lenient. The bill will also make provision in respect of offences from causing death or serious injury by dangerous driving. Following a campaign by the families of victims of road deaths, the bill will provide for a range of measures as follows. Firstly, an increase in the maximum prison sentence from 14 years to 20 years for causing death or serious injury by dangerous driving or by any of the 4 careless driving offences while under the influence of drink or drugs. Also, in respect of those offences, the minimum obligatory disqualification periods will be increased from 2 to 4 years, and for a repeat offender from 3 to 6 years. For the offence of causing death or serious injury while driving disqualified, sentences will also increase when tried in the Crown Court from 2 to 4 years, or at summary conviction from 6 months to 12 months. The bill will improve the current requirement for the judiciary to identify the exceptional reasons for not imposing an obligatory disqualification and for not imposing an immediate custodial sentence. For offenders who are disqualified because of these offences, they will not be able to have their licence restored before 2/3 of the qualification period ordered, or the obligatory minimum period for the offence has passed, whichever is the greater. The bill will prevent a repeat offender for any of these offences from applying for a reduction of the disqualification imposed until the obligatory minimum period for disqualification for a repeat offender, that is 6 years, has been served. And finally, where a driving disqualification is imposed at the same time as a custodial sentence for that offence, the disqualification period will be extended to reflect the custodial sentence imposed. The purpose of this is to help ensure that any disqualification will mostly be served after release from custody. Moving on, the bill will make provision in respect of tariffs for mandatory life sentences and release following a whole life tariff. On conviction for murder, the court must impose a life sentence and then decide the tariff, that is, the period the offender must spend in prison before becoming eligible for release on licence. The bill will set the starting points for the calculation of the tariff in statute and make a range of other provisions to provide clarity around the whole life tariff regime. With regard to the community sentencing provisions in the bill, suspended sentences do not currently include any further restrictions or requirements, and in our view this limits their ability to address the purpose of sentencing. The bill will propose to allow a suspended sentence to be tailored more to individual cases where a sentencing purpose or purposes can be met by the addition of one or more community requirements. Turning to sentencing for attacks on vulnerable victims, the bill will provide that where a person is convicted of any offence, the fact that the victim was a vulnerable person will become a statutory aggravating factor. The definition of a vulnerable person will include a child and a person whose ability to protect themselves from violence, abuse, neglect or exploitation is significantly impaired through physical or mental disability, illness, old age or any other reason. Turning then to sentencing guidelines, the bill will include provision for the Court of Appeal to provide or review guideline judgments without having to wait for a case to come before it, and the courts will be required to have regard to the guidance in those judgments and also current judgments that have already been identified as Court of Appeal sentencing guidelines. In addition to the provisions I have already mentioned, which are the outworkings of the 2016 to 21 sentencing policy review, the bill will contain measures in 2 additional areas: Charlotte's Law and hate crime. The Charlotte's Law provisions are designed to encourage those suspected of, charged with and sentenced for a no-body killing to give details of the location of their victims' remains or how the remains were disposed of. The inclusion of these provisions within the bill is as a result of the campaign led by the family of Charlotte Murray, who went missing in 2012. John Miller was convicted of her murder in 2020 despite denying the murder and her remains never being found. This was the first such conviction in this jurisdiction. The campaign has been supported also by the family of Lisa Dorian, who disappeared in February 2005, and whose body has never been found. On behalf of the Department, I would like to take this opportunity to thank both families for their support during the development of this policy and commend their continued dedication to honouring the memory of their loved ones. In summary, Charlotte's Law will make ongoing failure to disclose the location of the victim's remains or details of how they were disposed of a statutory aggravating factor, requiring an increase of at least 30% to the custodial part of the sentence or life sentence tariff that would otherwise be imposed, to reflect the impact that non-disclosure has had on the victim's family and friends and on society as a whole. The bill will then provide for a statutory reduction in the custodial part of the sentence where post-sentence disclosure is made. The amount of the reduction will be a proportion of the additional sentence imposed by way of aggravation and will reduce on a sliding scale the later the disclosure is made. The bill will also make provisions similar to Helen's law, requiring the parole commissioners to take non-disclosure into account when considering a prisoner's release at the end of their custodial sentence. Turning to the hate crime provisions, the bill will implement a recommendation of the independent review of hate crime legislation to include a statutory aggravator model for hate crime, so that when the offence is treated as aggravated and proved, the court should treat that as an aggravating factor to increase the seriousness of the offence, allowing for increased sentencing. Just to conclude with a few words on process and timing, we had originally hoped and intended to introduce the bill before the end of this calendar year. Unfortunately, there will be a short delay until the new year. Unfortunately, the drafting of any bill is a complex matter and some issues have arisen which require us to deal with those, and that's taking a little more time than expected. I do find this regrettable, but I suppose it will ensure that the bill to be introduced to the Assembly will be in as complete a format as possible. We also do not consider that the short delay will impact on the overall progress of the bill, and we look forward to assisting the committee with its scrutiny of the bill both during committee stage and today. Thank you.
Okay, thank you, Andrew. I will pass it out to members, but one question I have before I do is what issues have led to the delay?
So we have been finalising all of the drafting, and there's just a couple of wee sort of matters of detail that have to be worked out specifically in relation to the matters on sentencing guidelines and on the whole life tariffs. So we're just working through, those are pretty technical and detailed matters at the moment, so we're just unfortunately have to take a wee bit of time to work through those a bit more.
Okay, not to get into technical weeds now, but could you produce a paper on those issues?
Sure, yes, we can produce a paper on
the issues that have led to the delay.
Mm-hmm.
Okay,
sure.
Doug?
Thank you, Chair, and thank you for that brief. It was really useful. I've got three questions, if I can, please, to explore. First of all, if you go to page 159, unduly lenient sentences, which is good in part, but we're still not dealing with Magistrates Court. Why are we not putting in a procedure here to deal with unduly lenient sentences that are coming out of the Magistrates Court where we cannot do an appeal?
Okay, so I suppose the way we approach this is that the scope for significant failings in magistrates' courts is more limited than it would be in the Crown Court, because the vast majority of maximum custodial sentences are for 6 months. We also take the view that to extend the arrangements to some magistrates' court sentences would risk diminishing the purpose of the unduly lenient scheme, and maybe even add confusion over which offences are included. I don't know whether, Angela, you want to add to that?
Well, just maybe on a practical note, there is a resource issue as well, insofar as when we have approximately 25,000 court disposals per year, of those about 1,700 come from the Crown Court. So to extend the arrangements to all sentences, you can imagine, could have very significant implications in terms of extra work generated.
Yeah, and if I can come back on that, and you're absolutely, I get exactly where you're coming from, but I'm always minded that with all of these, there's still a victim involved. And I'll give you an example. An individual assaults 3 women, goes to the Magistrates Court, and for the assault on 3 separate women, gets a £300 fine. He could have got 6 months for each assault and a £5,000 fine, but he got a £300 fine. Now, had that been the Crown Court, I'd be appealing that. I can't now, and neither can the Director of Public Prosecutions. So you can see where there is instances where it's absolutely clear that sentence is unduly lenient, that there's no mechanism whatsoever for it to be challenged.
Yeah, I mean, we can't comment on individual cases, as you know, but again, I think we have to take into account the discretion and independence of the magistrate as well. And again, we've just had to take an approach here in drafting the bill that, on the whole, the scope for significant failings in the Magistrates Court is more limited. So again, that's just that is the drafting and policy approach we've decided to take here.
Yeah, and again, fair enough. And I'm not getting into the weeds here. But again, I'll say to you, when you look at the discretion we give the courts, that's fair enough. But I'm thinking about the victim here. You know, where they have absolutely no recourse whatsoever to take action in regards to this. And do you know what? To be honest with you, it's not the only one. When we look at the 329 cases of non-fatal strangulation of females, women and girls that go through the Magistrates Court, every one of them needs to be looked at. But that's fair enough. I think you've given me a clear answer, even if I don't agree with you. And I'll be honest, I don't agree with you. Can I just take you to a second point? And it's just on Charlotte's Law, if I can, please. I'm just scrolling to get it. And it's paragraph 9b. And it talks about post-sentence disclosure that will give them time off the sentence. Can you give us an idea of that? So in my head, that means, just in my head, that 10 years after a person has been given a 15-year life sentence, I'm just using basic figures, 15-year life sentence, he decides to disclose where the body is. That's what we want at the end of the day. But are we really saying we're going to give him time off his sentence after putting the family through that for 10 years? Or is it better to put this the other way around? That if he doesn't disclose, his sentence gets increased?
Well, we worked through really every stage of the criminal justice journey for that offender and tried to come up with options which would encourage disclosure at every stage. And in very close consultation with the families themselves, we've constructed this scheme which will give quite a significant increase to the sentence at the point of sentence, and then a proportionate reduction in that increase as time goes on, so that by the time they get maybe 10 years into a sentence, which for a murder could easily be a 20-year tariff, they're only going to get then half of the reduction that they could have got if they're given on the day of the sentence or the day after the sentence. So it's a reducing every day. It's a formula that will be applied so that it reduces every day, and there's that ongoing encouragement for them to make a disclosure at the very earliest point every day during that sentence. And
look, I think the main thing is the families have really plied into this, and that's a positive thing. What I'm doing is just scrutinising to get a better sense of it. For example, what if the loved ones have passed away by the time they disclose? So the loved ones have gone when the individual discloses that where the body is. Will that be a mitigating factor, do you think, to not giving him time off?
No, the time off will be automatic. It'll be a formula that will be applied, and there are
regardless if the families have.
There are other considerations beyond the family. There are friends, obviously, as well, and there's an issue for society in general of having a body that hasn't been found. So it addresses all of those people. Okay.
Oh, all right. Fair enough. Look, and the very last question, if I can, please, and it's page 165. Sentencing guidelines, and I have a real issue with sentencing guidelines, to be honest with you. And it says the courts will be required to have regard to guidelines. That doesn't mean they have to adhere to the guidelines at all. If they just have regard to them, they can actually decide what they want. And then as long as they justify that at a later stage, then that's okay. Is that how it works?
No, I think the obligation is to have regard to the relevant guideline, and then also if they don't adhere to the relevant guideline or if they're deviating from it, at that time they must give reasons for why they consider the guideline is not being followed. And it could be in relation to the circumstances of that particular case not necessarily fitting with the guideline, but at least the people present in the court will have some insight and understanding as to why perhaps what they anticipate might be occurring has either been deviated from. Equally, they might deviate from a guideline because they want to do a higher sentence because they've maybe identified additional aggravating factors. So having regard to it, we consulted on two options on the consultation, either having regard or required to follow. And there was a kind of not 6 of one and half a dozen of the other, as in whether that would make any difference. More important was that people wanted to understand why somebody gets X when there are guidelines that maybe give a range, and they didn't understand why that was fitted into that. So it's about an element of the sentencing guideline, is a large element, is trying to improve the transparency of why does the sentencer get to where they get at the end, provided they followed the necessary steps that the Court of Appeal has in many guideline cases repeatedly said. Sometimes they get it wrong. That's why you get appeals. That's why you get undue lenient references. Sometimes there's an error made, whether it's in law or whether it's in ignoring something that was in a guideline, or maybe not even giving a reason. So those matters. We want to improve both the sentencing approach, the avenues that people, both sentencers and those present in the court, have an expectation about them stating, why they've reached this sentencing range, what are the aggravating, what are the mitigating, whether they're of the offence or the offender, and then coming to their conclusion and reference being made. And it's helpful that most recently the Northern Ireland Court of Appeal also in a recent case has very much given an element of guidance to both counsel for the defence and indeed the prosecution about bringing to the attention of the sentencing judge any relevant guidelines in relation to it and asking them to really adopt that as a practice going forward. So sentencing is an evolving matter, but we're trying to improve transparency.
It is an evolving matter, and it is about transparency and consistency, but it's also about giving confidence to the general public. And I'll be honest with you, the general public are losing confidence in the judiciary and sentencing. And you see that time and time again. Because what you've just explained to me is perfect sense, absolute perfect sense for the Crown Court. But it doesn't perfect sense for the Magistrates Court, because you can't appeal the Magistrates Court. So if a judge goes outside of those guidelines and gives a valid reason but doesn't make any sense whatsoever, you can't challenge it.
Well, first of all... So
the guidelines then, which he only has regard for, he doesn't have to adhere to, he only has to have regard for, we can't challenge in the Magistrates Court.
Well, the definition of relevant guidelines that we've asked for will include the Magistrates Court guidelines. And it surprised us during the consultation how some people weren't even aware that they were in existence, and that they're there to improve that consistency of approach in sentencing. But so that will be there. So that those tiers, some of the Court of Appeal sentencing guidelines also apply those guidelines on the principles of sentencing. So that definition will be there. We're hoping by putting it in black and white law that also will heighten the awareness of any members of the judiciary maybe that aren't as aware. But we've got to remember the Magistrates Court is a court of summary jurisdiction. It's also not a court of record. So business in that court, particularly on pleas, you could have 22 pleas going through in the space of anything between half an hour and an hour. And I say that as a prosecutor for 10 years. So it is a court of summary jurisdiction. At the same time, judges do still try to give reasoned decisions, but perhaps we cannot expect the same length or detail of reasoning as we do expect in the Crown Court, and indeed as the Court of Appeal expects from the Crown Court. So yes, it is summary, and therefore the case that you mentioned, Mr. Beattie, about assault, particularly common assault, ranges from actually no laying of hands upon a person. It could be putting them in fear that you were going to do that, while that, and right up to then where somebody's been hit in the face but it hasn't left a mark. So you've a wide range, and without trespassing on the independence of the judiciary, one would imagine that without knowing all the facts, the injury or harm caused might have been slight or might be one of those fearful situations rather than that. Again, I'm just saying that from experience because I haven't seen too many £100 fines in 10 years when I was working as a prosecutor that didn't have, that was connected for no mark, you know, that somebody had a marks or had been laid hands upon that. So
Yeah,
I'm just trying to put it in
and
context. I'm hopefully just trying to put it in context.
No, and look, you put it in context very, very well. And look, I'm not challenging you or your knowledge, but in many ways, I'm one of these lay people who look at this from a distance and don't fully understand some of these things. Like, I don't understand why this individual didn't turn up to court and the police had to go and find him and arrest him and then bring him to court. And that wasn't a mitigating factor to getting a £100 fine for an assault on each of the 3 women. And there was actually 5 women who put claims of assault against them. And you're absolutely right, it might have been the absolute lowest level, but we're talking about public confidence here. But the point that I'm still making is that the judiciary only have to have regard to these guidelines. And that's my concern, regard for it. They don't have to adhere to it. Now, I don't understand why we don't be a little bit stronger on this. It doesn't undermine the independence of the judiciary, but they should adhere to these guidelines, not give regard to them.
I suppose the answer that we looked at is that one cannot predict in black and white letters all the myriad situations that may arise both in any offence. So if one considers assaults, murders, any of them, there are so many different ways that the act can occur. There are so many different histories that an offender may have. And there are also many different aggravating or mitigating factors that might play a part. Guidelines are guidelines. They don't cover each and every fact or that occurred in each and every offence. And the sentencing judge therefore has to identify what is the most suitable, first of all, offence. If there's multiple offences, they have to decide, first of all, what is the lead offence, the most serious, and that to take their first line from. And then if there's other offences, they'll also have to deal with those, but reflecting the principle of totality of sentencing. So therefore, that's why we're saying have regard to it, because until they identify which of the cases are the most serious, and then what comes in for the other multiple offences, each of those have to then be looked at and consider whether they're aggravating and mitigating factors for that offence within the range of sentencing for that offence. It's quite a complex exercise, which has a certain art, and I think that's why experienced judges are the ones that are put into the Crown Court. And there's a thing that they call ticketing for certain offences in the Crown Court. All of that's linked to the training that those judiciary have had to do to be able to hear those cases. So I think if you have stronger than that, where's the flexibility to reflect if the guideline doesn't do it? And I would say there's been a lot of criticism of the England and Wales sentencing guidelines about how prescriptive they are. And then you find that you get offences that the people are trying to fit them into 3 different categories. Is it a level 1, level 2, level 3? And then they try and they forget maybe certain aggravating factors because they're not mentioned in the sentencing guideline. And then that sentence is overturned or increased when they get to and appealed under the undue lenient references in England and Wales because they stuck rigidly to the guideline. So when we saw those critiques of that, we're trying to find a balance. And maybe at another time when one tries to work out, did this work? Did it improve matters? Did it provide a more consistency of approach in sentencing? Because I think that's the element that we need is consistency of approach in sentencing rather than consistent sentences, because sentences have to be reflective of the actual offender. You don't treat somebody who has no record the same as somebody who has 20 previous convictions for the same offence. So, they're going to be different outcomes. aggravating and mitigating, whichever they come in. So I think that having regard is giving weight. It's not a phrase that's unused, not used frequently in legislation. The judiciary know what it means. They know what the Court of Appeal in particular expects of them to do. If you're leaving, you better give a reason. There is Court of Appeal guideline cases in many judgments where they're criticising if somebody hasn't given a reason for something that in statute they were required to give a reason for. And sometimes it's been a reason for the Court of Appeal then to vary the disposal that was imposed at the Crown Court.
And that's a useful explanation. Look, I'll put my cards on the table. I think a sentencing council that they have in England and Wales and something similar in the Irish Republic is far more superior to what is being proposed here. But you've explained your reasons very, very well. Can I just ask a very, very quick one then, just with this? So why does the bill not have anything that creates continuous, compulsory personal development training for our judiciary? At the minute, we're telling everybody to get trained. Everybody to attend training. We just talked about the police to be trained and everybody else, yet at no stages are compulsory training for our judiciary. Is that not something to be looked at?
Well, I'm just not sure what you mean by compulsory, because I'm conscious that the Lady Chief Justice has a statutory duty to provide training. That I'm also conscious from the fact of liaison with the Lady Chief Justice Office that there is both regular training in lots of areas and cases referred and examples of areas to be worked with between the Judicial Studies Board that is mainly based in England and Wales, but which has a direct link to our training and judiciary provided here, not just in the criminal law, but right across each of the areas of judicial business. And that is supported by the work of the Lady Chief Justice Sentencing Group, where they meet at twice or three times a year, led by one of the Lord High Justice of Appeal. And they would identify both the Court of Appeal sentencing guidelines, but they also identify areas that are considered indicating a need for some additional training or refreshed training and that. So there is training provided every year to the judiciary in different areas.
Yes, no, you're absolutely right. Sorry, can I just clarify what I'm saying? Here is, there is training. Absolutely, there's training. I'm not disputing that. What I'm disputing is the fact is they don't have to go to it if they decide not to, because it's not compulsory. And it's not personal development either, and that's the point I'm making. So if the judiciary say I'm not going, they don't go. There's nothing compulsory. But if you go to the PSNI and you talk about domestic abuse training, it'll be compulsory for them, but not the judiciary. I don't understand why that would be the case. That's the point I'm really making.
I don't know that I would have an answer to that. In relation to it, Mr. Beatty, I can only say that any judicial training that I've attended has actually had quite good attendance, but that's an employment law, not anything else. But I can't say that there is, but I would suspect that, like anything, they're independent, but I have no doubt that there's persuasion if somebody was thought needed training. I think it's no different in that respect, perhaps, but it's just it's not black and white.
Well, I think persuasion's one thing. Legislation to tell you you're doing it is something else. But listen, that was really useful for me. Thank you very much for that. Thank you, Chair.
Okay, Doug. Emma.
Thank you, Chair. Thanks to you all for coming in and for that lengthy explainer, Máire. Thank you. I wanted to ask around engagement, particularly with the rights sector, in terms of the drafting of this bill. Have the Human Rights Commission been engaged here?
They have, yes.
Okay, and what was their feedback around proposals?
I suppose they're waiting to see the final shape of the bill when it's in its finished form, but at this stage they haven't raised particular concerns. They gave general advice just to be sure that we don't go against any retrospectivity that's detrimental to offenders, or the usual proportionality issues that feed into the human rights compliance, which we have been keeping quite a close eye to.
Okay, I suppose just looking at it, and with the review that had been carried out 3 or 4 years ago by Judge Marinan, the bit around like the protected groups. So I suppose we think of the Section 75 categories, and I know they're very extensive, and I think in what we've been presented, there's really only 4 groups specifically. Now, I know that there had been a conversation around broadening. I know religious groups is included, but there was conversation around broadening the sort of definition of sectarianism beyond just religious practice, and including people's, I suppose, cultural or nationalistic behaviours or how they present themselves within that, and then the specific bit around misogyny as a hate crime as well. And I think there was advice that should be included. What's the rationale for those particular categories not coming in?
I'll happily take that. I suppose introducing the statutory aggravator and starting with the 4 existing protected groups, and you'll be aware from the details provided in terms of the provisions. There is a second provision to introduce additional protected groups through secondary legislation at a later date. So that you're aware, obviously, that the hate crime provisions are going into mixture of the sentencing bill and the victims of crime bill, because we did not have the time in this mandate to bring forward a standalone hate crime bill. So I suppose it's get the statutory aggravator model on the statute books to start with, starting with the 4 protected groups, and then seek a power to introduce other additional protected groups through secondary legislation at a later stage. That
won't require primary legislation.
If the provision succeeds in the sentencing bill to take a power to introduce through secondary legislation, subject to positive resolution, additional groups.
Okay, because I know that the Minister had previously talked very positively around that introduction of sectarianism, in that broader definition. But is what you're saying the reason that these things have been omitted is like a timing pressure, or
it's timing, and also that there's a bit more work to be done on that. There's we've looked at other jurisdictions and to get the policy work and the consultation done, and to bring forward an aggravator referencing sectarianism. Just the time did not permit. So we're starting with the 4 existing protected groups, and seeking a power to add at a later date, whenever that sort of policy and thought has gone into other groups that might be appropriate to add.
Okay, and I suppose as part of that, going back to the misogyny again, and sort of future-proofing this, and as we look at the strategy that is there around violence against women and girls, in the hope that these strategies and pieces of legislation will complement each other. So your hope would be that could be added then at a later.
I think it would be fair to reflect the Minister's view that misogyny, perhaps not as a hate crime, but looked at separately as a particular offence. So perhaps not part of hate crime. And we did look at sex as a potential protected group. The truth of the matter was that there wasn't a lot of evidence that people were motivated to, take an example, to assault someone or to attack someone purely out of a hostility or a hatred driven by, I hate that person because they're a woman or because they're a man. There's not a lot of crimes based purely on that hostility driven by the aggravating factor of hatred because of someone because of their pure gender. There are incidents, I could quote some, where that was a very obvious motivating factor, but it's not as prevalent perhaps whenever we looked into it.
And where's that evidence base coming from, or who is?
That's again we reflected obviously on the work that Judge Desmond Marinan did, and then also looked at crime types and stats to see if we could identify incidents, because sometimes they are informative as part of the policy development process. So getting
a range of incidents and crime stats that would demonstrate that the aggravation was purely motivated by hate for someone because of their gender. Wasn't as prevalent or as obvious to us as perhaps we might have thought whenever we started that work.
Yeah,
so that is it's part of the phase 2 consultation and policy work for additional provisions, because you appreciate we're only implementing an additional, Minister refers to them as sort of foundational provisions to modernise hate crime legislation, but there's lots of further work needed, and that would be one area that we'd want to explore in more detail.
And forgive me because it's a number of years ago, but I remember at the time of the Marinan review, and we had at that stage I was engaged in the Bill of Rights process here, and we had looked at it quite extensively, and from my recollection misogyny did receive a focus there. And I suppose the whole, I mean, to say that people are not being attacked because they're a woman, it sort of flies in the face of everything that we see around misogyny as the basis
and
for
separate. Misogyny takes on different forms and behaviours, and when talking about hate crime and talking about hostility motivated purely, I attack you purely because I hate women, that isn't as prevalent a feature in our experience, but we will come back to that, and that would be one of, sex is one of those groups that could be added at a later stage.
Yeah, just on, you see, because I suppose that's something that I have an issue with, because I would argue that in order to carry out any of those crimes, the sort of prereq is that you devalue, dehumanise, hate women. That's sort of like the basis of it, and I suppose it's been the normalisation of it that allows us to have the history that we have in relation to gender-based violence here. But I know there was also an omission, or there had been a conversation around looking at gender and including trans people within that, and that hasn't come to pass either. Is that still in the mix?
Yep. Again, age, sex, transgender identity are 3 typical groups that potentially could be added at a later stage, subject to securing the provision to add those protected groups at a later stage through secondary legislation.
Okay, so it's all going to be, so that's dependent on that being passed as part of the bill.
Get the statutory aggravator model up and running, and potentially add additional characteristics protected groups at a later stage. Is that's the proposition that is in the bill as it sits at the moment.
So just with that in mind, then the part around sentencing for vulnerable victims, what constitutes vulnerability there at present, in your understanding of how this is going to play out?
Yeah, to kind of perhaps a reference to the children.
Vulnerable victims will include children and anybody whose ability to protect themselves
is hampered
by reason of various characteristics.
Okay, thanks, Chair.
Okay, Connie.
Yeah, thank you. I just wanted to ask about Charlotte's Law. I think it's really important that we make progress on this, and I think you do have to pay tribute to the campaigners, Charlotte Murray and Lisa Dorian's family, for pushing this through. And I wanted to know how the department and you've engaged with these families and campaigners for Charlotte's Law, how it compares and goes further than Helen's Law, or how aspects of that will be incorporated, and how people who've been pushing for this and how victims feel around the statutory reduction if a disclosure is made post-sentencing as well.
In terms of how we've engaged with the families, you may remember shortly after Johnny Miller was convicted and sentenced, Charlotte's family began a campaign seeking to introduce provisions similar to Helen's Law here. There was an Assembly motion and a lengthy debate, and on the back of that we undertook to look beyond Helen's Law, because the point about Helen's Law was Helen McCourt's murderer was being released at the end of his life sentence when her mother brought the campaign for Helen's Law, which was to seek that the parole commissioners would not release him at the point when he could potentially be released. The situation is very different in the Charlotte Murray case because Johnny Miller had just been sentenced, so there's going to be a 16-year period before Helen's Law could have any impact. And we thought it was important to try to create, as I was saying earlier to Mr. Beattie, a series of measures that could encourage disclosure right from the beginning when somebody's questioned by the police. So we got in touch directly with the families. We met face to face with them, and we started a process of engagement with them, which has gone on ever since. We've had quite a number of meetings directly with them, and developed the ideas and thinking behind the proposals are now in the draft bill. And as far as how these matters go beyond Helen's Law, as I mentioned already, Helen's Law really only kicks in at the end of the sentence when the person is being considered for release, whereas Charlotte's Law tries to address the issue much earlier in the process and on an ongoing basis.
No, thank you. I think that's positive. And Chair, if I could ask another question, really on another aspect of the bill, which is causing death or serious injury by dangerous driving, and that's something again that I think everybody wants to see progress on. And I will particularly think of Jaden Rice, a 16-year-old who was killed this summer. How have you engaged with families who have lost their loved ones by dangerous driving? And particularly I did want to ask as well around the disqualification periods if someone's caused death by serious injury, if caused death or serious injury by dangerous driving while under the influence of drink and drugs. Was mobile phones considered to be included there as well?
Or I take that
one?
Well, I'll deal with the last part of the question first, maybe.
Yeah.
No, mobile phones weren't considered in relation to it. Although somebody using a mobile phone could well be an element of dangerous driving, depending on the driving in question that results in an accident and the evidence that then's collated. It quite clearly would be an element in a dangerous driving because it causes people to fall well below the standard expected of the reasonable driver, and that's part of the test for dangerous driving. The commitment made, we focused on those that the commitment was made to be included in the sentencing review. And you then asked about engagement. There's a number of families, I'm sure, which probably the members even are aware of because they've been in the media. There's the parents of Enda Dolan, the parents of Martin Gallagher, and the parents of Leslie Ann Carraher in particular. And they've all been engaged with us during the part of the review. The Minister has regularly met them. We very much involved them in taking time to explain when we got to reaching conclusions with the Minister about what we would propose in the bill, because it wasn't exactly what was being talked about in England and Wales. And we wanted both to ascertain their view, but also to gain their understanding and acceptance. And they're very supportive of what we propose, because I think when one looks at what has happened every other time, when the penalty for this increased from 5 years to 10 years, and then from 10 years to 14 years, on each occasion what you found was the senior appellate court in each jurisdiction considered how that impacted on the 4 categories of culpability that they call, which play into the range of sentencing that a sentencer should be considering about. And the difficulty that we perceived was if going, as England and Wales did, to a discretionary life, when you put that in the context of the 2008 Criminal Justice Order, and for England and Wales it would be the 2003 Criminal Justice Act, where there's like a staggered approach when it's discretionary life that the sentencer must do. They must first consider should this be life, and should, because it's a maximum penalty, but is there no other sentence that it could be? And there's certain judicial precedent that says how it should only be used for the most odious, serious and grave element of whatever offence carries discretionary life. And there's lots of offences carry discretionary life as the maximum. We felt that going to a fixed term, first of all, for this offence, we would get the same exercise carried out by the appellate courts, which would be that they would review the existing, which would be this in the Stewart case in 2017, the ranges when they reconfigured what was the previous McCartney guideline, which was done when it went to the 10. That therefore we ourselves did this kind of certain exercise to project how that might look. Because then if a repeat offender comes along who will be vulnerable to discretionary life, the court will be dealing with that. The sentencer will be looking at what is the reconfigured sentence ranging for offenders of carrying the 20 years, and will rely on that to probably look at what should be the tariff on the discretionary life, while otherwise we wouldn't have a new guideline. We would be sitting with the Stewart ones, which are based on 14 years, and would that be what the sentencer would look like? Because that would be the last available guideline that they would have. So the family did they've bought into that, they accept that, and could see that there was a certain sense and rationality to it, because experience shows that having some idea of where those ranges are, helps both the family before they even go in, if they have that opportunity to have it explained to them. So we think it's a better solution than, as I say, immediately going discretionary life.
That's good. Brian?
Okay, thank you for your attendance, and look forward to the bill coming forward. We hope it will help with consistency, with justice, with public confidence, and as deterrence. In terms of the consultation that you've carried out, have you engaged with the relevant authorities, with the police service, the courts and tribunal service, the judiciary, to ensure that the bill will be as complete as possible and fit for purpose?
Yeah, I mean, there's been a wide range of consultation and engagement right across the justice family. So I know, for example, that we have, first of all, had a very good look at potential costings of some of the provisions, and we think that on the whole, mainly the provisions of the bill will be able to be dealt with from existing resources. I think the big exception to that maybe is the community sentencing provisions, where there will, I think, be some additional costs. So we were working through the detail of the potential costs on those at the moment in time with our financial colleagues, and that will also require, I think, some more investment in the probation board. So we have engaged initially with them, and will continue to do so. In terms of the judiciary, I think we have also had some discussions with the Lady Chief Justice's office.
We had a very fulsome pre-consultation range of engagement events, which we focused on each element of what the consultation was going to be. And we had public events, we had focused events, we had one-to-one meetings with victims' families. So across the whole piece, we have consulted extensively. Mm-hmm. I know the Lady Chief Justice gave a presentation at University of Ulster earlier this year on sentencing, and she referenced the proposed bill in positive terms.
Okay, that's good.
So
one could imagine you might get some pushback from the judiciary, but on the whole, you would say...
On the whole, it's been welcomed.
Okay.
We don't think there's been a significant fettering of judicial discretion, which would be the concern, obviously, for the Lady Chief Justice.
Because the whole point is to have consistency, and also just to meet where there's been concerns about unduly lenient sentencing. Okay, thank you, Chair.
Just on that point, what about the Northern Ireland Human Rights Commission? What have they said?
Yes, well, I actually met with them yesterday on the bill as a whole and gave them an overview of everything that we're planning on doing, and they didn't raise particular concerns on that. And previously I'd discussed in more detail with them the Charlotte's Law provisions. And again, no particular issues raised. And obviously we've been liaising very closely with our colleagues in Departmental Solicitor's Office who will provide the competence advice ultimately.
What about the Commissioner Designate for Victims of Crime?
Yes, she has been involved along the way as well. Interestingly, she was actually part of our original reference group when we started the whole review back in 2017 or 2018. So she's been quite closely involved.
What about her views on the personal statements, victims' personal statements being used, and then the access to sentencing remarks?
On personal statements, I think we haven't dealt with those in the sentencing bill. We will be looking at those separately, just in terms of their efficacy and how they will work in practice. What was the other one you mentioned? Sorry,
the access to sentencing remarks and the victims' personal statements.
Yeah. So in terms of the sentencing remarks, then yes, I mean I think there is a long-term intention that there will be access to sentencing remarks. How
will we achieve that if it's not through statute?
Well, I think it will be through statute in due course, but not through this vehicle. I think there will be a need for legislation, and that will be tied up with the broadcasting provisions that will probably be being brought forward.
It's also going to be taken forward as part of the victims and witnesses strategy.
Right, okay. It might well be in that bill then.
I wouldn't like to say.
Hot off the press there, maybe. Okay, Ciara.
Oh, thank you. Just a few questions, and it's particularly around the offence of assault on a person while working, providing services to the public. So just kind of clarity on or defining what is services to the public and what criteria will be used to determine that. And likewise, will the bill or guidance include specific reference to retail workers? Because I know the Minister gave a commitment to that.
Yeah. The widening of this offence from just originally intended to be the emergency services to really any person providing a public service was largely driven by the campaign by the retail sector. And then in addition to that, the Minister was hearing a lot of concerns from people in public transport. The Law Society have approached us about solicitors. There's a whole range of people who provide a service to the public who seem to have become fair game for assaults, and the Minister's very unhappy about it. So her intention is that this will be as wide a provision as possible to capture all of those occasions when a person in the course of their work is the subject of an assault.
Oh, so by not being prescriptive, that's nearly everybody, anybody that's front facing.
We have thought in detail just to go, could you have a list? And we've rejected the idea of having a list because A, we could very easily miss out something, an occupation. B, new occupations are being created all the time, so you'd have to keep it constantly updated. But I mean, for example, there's the very obvious public facing workers, so the emergency services, health and social care staff, retail workers, as you say, public transport workers. There's ones that also that you maybe wouldn't automatically think of. So there were reports in the press during the summer there just about broadband workers. So people who are going out to homes and installing broadband, being potentially victims of assaults. So we say that the broadband engineer who is assaulted is providing a service to the public under the terms of this legislation, and therefore that would be within scope. So there's the very obvious ones, and then the ones you need to think about a bit more. So that's why we
volunteers working, say, in a community and voluntary organisation would likewise they're delivering a service to the public will be included.
Yeah, there'll be a specific provision saying it doesn't matter whether they're paid or not paid.
Not paid. No, well that would be useful. No, thank you for that. The sentencing bill takes into account the new offensive or aggravating fact that's been proposed by the planned deepfake amendment to the Justice Bill. Does that include that? So I'm just trying to think, are each of the proposed bills interrelated and are they being taken into consideration? So we're looking at deepfake now. with the
Yes.
Justice Bill.
Yeah.
Is that going to be considered in this bill?
We'll certainly have a look at that. We are in the process just of drafting or finishing our instructions on the deepfake amendments. So we will certainly make sure that both of the provisions are compatible with one another.
I just wanted to follow up on the chair. I would be really interested in the consideration and the reasoning why at this moment in time the victim's personal statements and access to sentencing remarks aren't included within this bill. I'd be really useful to get more in-depth detail as to why. And then finally, just I'm concerned regarding protected groups. I want to go back to Michael, just particularly around the gender and the evidence base to suggest that it's quite small in number, etc. I would really love to be privy to that information, because generally from my own perspective it's huge, and anybody that I'm speaking to, it's huge. And likewise was even online hate crime, particularly in relation to gender, was that taken into consideration? I think it's a huge group, and I would have preferred to see it included as one of the protected groups at this moment in time, rather than leaving it to secondary legislation. So I'm just asking, could it be re-looked at, considered, and and re-looking at the grounds as to why it hasn't been included on this bill, given.
I'll start off just with the sentencing hearing, the transcripts, the remarks. So I suppose that we have been looking at this. We've been working with colleagues across a number of organisations just to look at options for providing access to victims for transcripts of the sentencing remarks. Yeah. So we are at the moment undergoing some work in regarding costs, considering costs and delivery mechanisms of that. To be very honest, I don't think we are ready to provide those provisions in this bill. I think we do need to do further work under the auspices of the Victims and Witnesses Crime Strategy, for example. So being very honest and levelling with you, I think further work is needed. They're not ready to be included in this bill. I think probably the same applies to the victims' statements as well.
Sorry, can I ask, what is the issue with the victim personal statements?
Ensuring that they're obviously the Victims Commissioner, and I know she's done extensive work with people, and it's a huge area where victims themselves, particularly women, who have been subject to domestic violence and have been going through the courts, it's an area that they would recommend to have access to the personal, the victim's personal statements and the access to the sentencing remarks. So I'm just concerned why, given it's a huge area and the Victims Commissioner has identified it, why it's been omitted from this bill when it comes to sentencing.
Yeah, well, as Andrew says, the Victims and Witnesses Strategy is looking after those issues more so than us. But as far as the victim personal statements are concerned, there had been an issue about people wanting to be able to read them out in court. And I think it's been clarified that they are entitled to do that if the court gives its authority for that to happen. Otherwise, the victim personal statement is considered by the court before sentencing. And my understanding of the issue was that it was that issue about victims wanting to be able to have their voices heard in court, which perhaps isn't something that is not allowed. It certainly can be allowed. But I say it's something that colleagues in Victims and Witnesses team are looking at.
We'd be happy to maybe take a more definitive view and come back to you.
Yeah, definitely. No, I would appreciate that. Okay.
Thank you.
I was going to say, Chair, if it's helpful, I'd be happy to write to the committee to provide some more information. That example that I was referring to earlier, I don't think we're at cross purposes here. I really don't. I think it's a case whenever we looked at hostility motivated, it's more obvious if someone clearly is motivated through hostility towards someone because of their sexual orientation and assaults them. That's obvious. But when we looked at the number of crimes that were committed, we were getting down to a relatively small number of incidents, very serious incidents, where someone rides around Belfast on a bicycle. You may remember the case, and gets off their bike and stabs a woman, and rides along the street past 10 men and gets off their bike and stabs a woman. Clearly there was an aggravation there which was driven by hate for women, but there weren't that many incidents that were as clear cut as that. But if it's helpful to the committee, I'd happily share some of the thinking that went into that.
Yep. Yep.
And particularly would they look at any evidence base regarding other jurisdictions and particularly online hate crime, where it's gender specific, would be really, really useful, and the trends that are happening elsewhere.
Okay, are you finished?
Yeah, thank you.
Okay, thank you. Can I just bring you back then to the assault on public workers? I changed the law in 2016 to bring ambulance workers in who were assaulted into line with firefighters and police officers. It's that period of time I remember very well. I think it was 6 months, up to a sentence of 6 months, and then 2 years indictment. This is 12 months imprisonment on summary conviction or 2 years in indictment. Why has the 2 years not really moved? Maybe there's a reason, valid reason for that. Yes. But what then happens to those 3 specific workers and the specific law on assaulting them? Do they automatically fall into this, or will we need to amend those specific assaults to bring them up?
Provided we don't lose anything, our intention is to revoke those 3 existing assault offences, and then they will all be included within this new all-encompassing one.
Right.
I know with certainly the assault on police offence includes resisting a police officer.
Yep.
And other elements, so we need to make sure we don't lose anything.
Yes.
But the intention is that this new offence will be applicable to all. And the reason then obviously is because there'll be a higher maximum in the magistrates' courts, and as you point out correctly, we're keeping the same maximum on indictment. And the reason for that is that when we looked at the figures, when we saw the actual convictions that were being given, there weren't really any examples of 2 years being given, so there didn't appear to be a problem with that at that end. But in the magistrates' court, there were quite a number of 6 months being given, which is unusual for the maximum to be given in any case.
Yep.
So that identified an issue there, and that's why we increased at the magistrates' court level.
Yeah, are we sure, a bit like Doug's point with regards to non-fatal strangulation, are we sure that these cases are going to the right court?
Well, that's a matter for the PPS to decide on the facts of each case, which the correct court will be.
Okay.
Obviously, as Andrew said, this offence is really at the common assault level, which is at the lower end of the offences against the person. And as you can tell from the papers, if a more serious offence is being charged, the fact that the victim is a public worker will then become an aggravating offence.
So the new assault on public workers, and I get it, and I think we all support it, but it's going to affect, in fact, if you're going to produce a list, you produce a list of people it doesn't affect more than, so it'll affect the nurse in the emergency department. Will it affect the cleaner?
It could do.
Yeah, I mean, I see a cleaner who is employed by the Health and Social Care Service as someone who is providing a service to the public.
Okay.
So
a social worker going into a domestic setting?
Yes.
An electrician going into a domestic setting?
Yes.
Even if they don't work for the government?
They're providing a service to the public.
Okay.
Yeah.
What if you are a cleaner or a doctor and you're walking through the accident emergency division to get to your car? Your shift's finished.
The intention is that it will only apply when you're in the course of your work.
Yeah.
Yeah.
Okay. Well,
is to protect people when they're providing that service.
Yeah. And the reason why I felt that the ambulance workers had to be up with the power of the police and firefighters is that they were performing a function that protect life or keep people healthy. You can't say the same for every public health worker, or I'm sorry, every public worker.
That's true.
So should there not be another elevating level for people who perform a service that protects the sanctuary of life?
I appreciate your point, absolutely, but the Minister was not keen on creating a complicated hierarchy of victims, and she felt that really if somebody was at work and they were subject to some kind of attack, they needed to be protected, and that was the same across the board, although obviously there are those cases, as Andrew's mentioned, which are very much more obviously falling into these categories.
Yeah.
But the same applies for anybody going to work. They shouldn't be in fear.
Yeah. So I suppose my point is you can perform a public service, but then these very special people perform a service that save life, and if they're out of commission because they've been assaulted or have become a casualty themselves, then they can't perform that function, and somewhere along the line someone could die because they have been. You can't say the same for a shop worker, with all due respect.
I suppose the other point then is when the case actually gets to court, the court will take into consideration the particular facts of the case, and may treat that kind of thing as more aggravating.
Okay. You have undertook as a department a consultation on sentence reduction for guilty pleas. Also, you've consulted recently on the proposals for increase to existing maximum sentences for offences of causing or allowing a child or vulnerable adult to die or suffer serious physical harm. Why is the product of that consultation not contained within this bill?
I cannot speak for the second one. First, I think we'll have to come back to you.
I can give you some.
You can give some information.
The causing the child to die was not included in this consultation because it was taken forward again by other colleagues in the department, and it was taken forward at a time when a lot of the preparatory work for this bill was already complete. It wasn't really originally the intention that this bill would deal with specific penalties for specific offences, although having said that, I accept that we have done that with the causing death by driving offences.
Yep.
But the intention of this bill was more to do with sentencing policy, and so overall it was considered preferable that the causing child's death provision would be carried elsewhere.
Go on ahead, Andrew.
On early guilty pleas, it's a very simple case of it has taken us some time because it's the same very small team who have been producing the bill and preparing for the new sentencing review has also been responsible for analysing the consultation responses for early guilty pleas. So we simply have just run out of time. We will be seeking to publish the early guilty pleas consultation very soon, consultation response very soon. But cards on the table simply ran out of time.
Okay, is the department or the minister intending to include any amendments to this bill akin to the experience we've suffered with regards to the Justice Bill?
No, it's at the moment the minister is not intending to make any amendments to the bill as far as I know, and the intention is that we will be providing you with a clean version for introduction in January. And say we did briefly consider on a couple of issues that we've had a slight delay on, whether we should just go ahead and introduce and maybe make pre-amendments for those in the future. We thought we'd just better make a clean break of it. And
I would suggest to you that's not necessarily a bad thing, and there might well be something that this committee suggests that the department should bring by way of amendment. What I don't want to see is half a bill at second reading.
Well, that's not going to be the case here. We've been working exceptionally hard just to give you a bill which is a whole, complete, accurate, deals with all of the issues that we said it was going to deal with and at introduction stage.
In your summary of the proposed content of this bill, the very last line, and this is my cynical mind, you write, we also seek provision to assist with the accessibility and awareness of sentencing guidance. What does that mean?
So that's the sentencing guidance provision that we're again just finalising the drafting of. So that's essentially what we've discussed, I think, Máire, isn't it? In terms of
there's quite a bit of to and fro that you can imagine occurs when there's really not something in legislation, but there's an awful lot of judicial precedent or in the background. So far as, like, most of the Court of Appeal, what are called Court of Appeal sentencing guidelines, the judgment doesn't refer to it as a guideline. Recently they've started maybe doing that in some cases, but there's very few of that, and they're kind of identified subsequently to having been delivered, so anybody in the court might not know which part of it was guidance and which part of it was just obiter dicta, or which was ratio descendi, and there's this whole complication between being based on judicial precedent. So, first of all, is it not only getting, shall we say, what is a guideline and who's giving it and when it's given, it being known that that's a guideline as at the time it happens. So we're proposing something like a freestanding power to the Court of Appeal to do so, because one of the big complaints at times, even on the Lady Chief Justice Sentencing Group report work, is them having to wait for a suitable case to come before them to even give the opportunity to review an earlier guideline. On the other side of it is raising public awareness about these guidelines. We had engagement with the retail workers. It was a big surprise to them to know that there was a guideline about theft and actually included as an aggravating factor being a shop person working and that. And on the same side, we've had communications that would indicate that sometimes even those working in the legal game may not be aware always of the guidelines. So, but we think that will be that area of work in, shall we say, the profiling or raising that awareness. Part of that we hope will be resolved through some administrative and discussion with the Lady Chief Justice Office. Mainly because there is the Judiciary NI website, and it is very well signposted on that website. And there have done recently, from when we first started this preparing for the consultation, and that some of the work that we did with, in terms of to and fro with the office, about the work of the steering group, the Lady Chief Justice steering group, is reflected now in a higher profile of where the sentencing guidelines can be found, where the magistrate court's guidelines are, and that. So users, as in the legal profession and the judiciary. But the important thing is, one of the feedback we got in the consultation was that the ordinary members of the public who are in the court would like to know why that's happening and what's happening, so that they have some understanding on it. And more importantly, the victims really wanted to understand what could they expect to happen, and rather than to feel that they were content or that they were satisfied justice had been done. And part of that is that referring to a guideline if it's relevant. So both the prosecution, and there is practice protocols that have been there since 2012, for the Magistrates Court, saying that both prosecution and defence should be prepared to refer the magistrate to the relevant guideline as relation to it. So again, there's some administrative discussion to go on to see how we improve. We don't need legislation to do that when there's a practice protocol. But if it's not happening, then we do need to have discussions with other stakeholders to improve the sentencing, what I would call the sentencing route between all parties.
Just last question for me. You've fallen short of Harper's Law. Angela, I know you and me had a discussion of this previously with a avid campaigner. Where are we with Harper's Law?
So Harper's Law is going to be part of the new review of sentencing policy that's going to be announced before the end of the year. We're going to be including that in Harper's Law in the review. We had originally intended, I think, to launch the review at the same time as we introduced the bill. We are still going to launch the review on plan timescale before the end of this calendar year, and it will include Harper's Law. So that's what's happening in relation to that one. Is there anything else to add in relation to Harper's? I think that's as much as we can say today.
Okay, no problem. Okay, thank you. There's no other members want to come in, so it just leaves me to thank you very much for your time here and for answering our questions. It's been very, very helpful and useful, so thank you very much. Thank you. Okay, members, we're going to push on because we are struggling for time here, and I don't want to lose quorum. So just want to warn everybody, if you can't stay, stay please. Agenda item number 6 then is Justice Bill.
I do need to go, I've got another event, sorry.
Department of Justice response regarding delegated powers within the Justice Bill and amendments. Can I refer members to page 168 of the meeting pack, which contains a response from the Department of Justice to questions the committee had raised in relation to delegated powers within the Justice Bill and proposed amendments. Can I remind members that the committee had asked the Department to consider amending the procedure used in the new XSNI Clause 29A, matters to be included in criminal record certificates, from the negative procedure to the draft affirmative procedure, and the Department has advised that the Minister has noted the committee's formal request and is content for departmental officials to coordinate with the OLC to make the necessary changes to the final draft of the amendment prior to tabling for consideration stage. So can I inform members that the Department has also replied to other questions that the committee has asked regarding biometrics and live links. Can I ask members if they are content to note the Department's response, or any further information or clarification is required at this time? Content? Department of Justice response regarding the Justice Bill removal of defence of reasonable chastisement. Refer members to page 174, which contains follow-up information from which Department of Justice officials agreed to provide as part of the joint oral evidence session with the Department of Health on the removal of defence of reasonable chastisement. Can I ask members if they are content to note the Department's response? Content? Department of Justice then response to the Justice Bill repeal of vagrancy legislation amendment. Can I refer members to page 178, which contains a response from the Department of Justice to questions the committee had asked following the oral evidence session with Professor Kevin Brown on the repeal of vagrancy amendments. Can I inform members that the Department's response contains clarification on the other offences which are tied up in the wording of Section 4 of the 1824 Act that will drop off the statute books when it is repealed in order to decriminalise begging and rough sleeping, which the Department believes can be covered by alternative legislation following appeal. We would suggest that the PSNI are maybe a wee bit nervous around that. The Department has also advised that Professor Brown's suggested amendment to cover begging causing harassment, obstruction or public order has been forwarded to the Minister and the relevant policy leads for consideration. However, the Department has not provided any indication on when any views the Department has on this might be conveyed to the committee. So can I seek members' agreement to ask the Department when it will be in a position to advise the committee of its views on Professor Brown's suggested amendment? I think it's important now, given the evidence we've received from the PSNI. Members content?
Yep.
Homeless Connect then, response regarding the repeal of vagrancy legislation. I refer members to page 185, which contains a response from Mark Bailey, who recently gave evidence to the committee on behalf of Homeless Connect. Can I advise members that in his correspondence, Mr Bailey has advised that they would like an opportunity to consider the responses to Professor Brown's paper on the repeal of vagrancy requested from the Department of Justice and the PSNI first, before setting out Homeless Connect's position. Can I seek members' agreement then to note the correspondence and advise Mr Bailey when the response from the Department is available? Agreed.
Maybe forward that on.
Yeah, when it comes in, we certainly can. And maybe we should allude them to the evidence session from PSNI,
given that they didn't present their
because they were quite, stark about it. Justice Bill then request for further information. I refer members to page 188 of the meeting pack, which contains the latest version of the document prepared by the committee team to track committee requests and responses received in respect of the Justice Bill and proposed amendments. Can I seek agreement to note the list of requests and responses? Agreed.
Yeah.
Okay, we now go into agenda items number 7 to 12, which are fee orders. So please bear with me. Advise members that the next 6 agenda items concern individual SL1s received from the Department of Justice in relation to uplifts of court fees. Can I remind members that at the meeting of the 13th of November, 25 members considered a paper from the Department of Justice which provided an update on the outcome of the Northern Ireland Courts and Tribunal Services public consultation on charges to court fees for a period 26 to 29. The committee sought further information on a number of matters, including equality screening and the support that is available in the family court system. The Department's response begins at pages 255. Can I advise members that the proposal for 6 statutory roles following the consultation have now been received? All 6 SRs are made under powers conferred by Section 116, brackets 1 of the Judicature Northern Ireland Law Act 1978, with the concurrence of the Department of Finance and after consultation with the Lady Chief Justice as required by Section 1161 of the Judicature Northern Ireland Act 1978. The Department advises that purpose of the fee increases is to strive towards a position of full cost recovery in the provision of civil and family court business, a requirement that is placed upon Northern Ireland courts and tribunal services by managing public money. Only 84% of the full costs are currently recovered. Each of the rules are proposed to come into operation on the 1st of April 2026 and covers the increase to fees over a 3-year period. They propose amendments to their respective fee orders that will provide an initial increase of 5%, followed by a further increase of 2% on 1st of April 27 and a final increase of 2% on the 1st of April 28. The rules are not subject to any procedure, as Section 119 of the Judicature Northern Ireland Act 1978 provides that an order made under Section 116 of the Act will not be subject to any procedure. However, the Department states that in making these SRs that it has undertaken to comply with the 21-day rule. So can I advise members that the relevant consultation, impact assessments and Section 24 information on each of the proposed rules can be found in the individual SL1s. Can I advise members that all of the information is consistent with each of the 6 proposed rules, so I will not be repeated. Will not be repeated as members now consider the SL1s individually. So, SL1, the County Court Fees Amendment Order Northern Ireland 2016. Can I refer members to pages 229 to 255 of the meeting pack for the relevant papers? Can I inform members that this proposed rule will amend the County Court Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees for the delivery of civil and family proceedings in the County Court, as well as prescribing new fees in the Small Claims Court? Can I ask members if they are content with the proposal for the statutory rule or any further information or clarification is required? Are we content? Agreed? Agreed. Agenda item number 8 then is SL1, the Magistrate Courts Fees Amendment Order Northern Ireland 2026. Refer members to page 291 to 310 of the meeting pack. Inform members that this proposed rule will amend the Magistrates Court Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees charged for the delivery of civil and family proceedings in the magistrate courts and prescribe new fees. Can I ask members if they are content with the proposal for the statutory rule or any further information or clarification is required? Are members content? Okay. Agenda item number 9 is SL1, the Court of Judicature Fees Amendment Order Northern Ireland 2026. Can I refer members to page 312 to 333 of the meeting pack? And I inform members that this proposed rule will amend the Court of Judicature Fees Order Northern Ireland 1996 to provide for inflationary increases to the majority of existing fees for delivery of civil and family proceedings in the Court of Judicature. Can I then ask members if they are content with the proposal for stat rule or if any further information or clarification is required? Agreed? Agenda item number 10 then is SL1, the Court of Judicature Non-Contentious Probate Fees Amendment Order Northern Ireland 2016. Refer members to pages 335 to 344 of the meeting pack. Can I inform members that this proposed rule will amend the Court of Judicature Non-Contentious Probate Fees Order Northern Ireland 1996 to make inflationary increases to existing fees for the delivery of non-contentious probate proceedings in the Court of Judicature. Can I ask members if they are content with the proposal for the statutory rule or if they need any further information or clarification? Agreed? Agreed. Agenda item number 11 is SL1, the Family Proceedings Fees Amendment Order Northern Ireland 2016. Refer members to pages 346 to 361 of the meeting pack. And I inform members that this proposed rule will amend the Family Proceedings Fees Order Northern Ireland 1996 to implement inflationary increases for the delivery of business in respect of family proceedings, as well as prescribe a new fee for an ex-party application to a judge in matrimonial proceedings for an injunction. Can I ask members if they are content with the proposal for the stat rule or if any further information or clarification is required? Agreed? Agenda item number 12, SL1, the Judgment Enforcement Fees Amendment Order Northern Ireland 2026. Refer members to pages 363 to 374 of the meeting pack. Can I inform members that the proposed rule will amend the Judgment Enforcement Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees for the delivery of business in the Enforcement of Judgments Office. Can I ask members if they are content with the proposal for the statutory rule or if any further information or clarification is required? Agreed? Okay, agenda item number 13 then is Police and Criminal Sorry.
Just on all of them, obviously we've agreed them today, and I do welcome the department in relation to including a review mechanism now that has been built in, and I'm conscious because of the impact, and they have done a U-turn on that 50% subsidy for children and families, which is excellent. I would just ask, can the department go away just and do a double check on ensuring that they have done a thorough analysis of the potential impacts across them all, and as a result of these fee increases. And I know they have a built-in review, but just as a double check, it would be really, really useful that they do it.
Okay.
Is that all right?
You can ask that. Agenda item number 13, Police and Criminal Evidence, Northern Ireland Order 1986. Outcome of the consultation on the list of qualifying offences as specified under Article 53A, the Department of Justice written paper. Can I refer members to page 376, which contains a written paper from the Department of Justice on the outcome of the consultation on the list of qualifying offences as specified under Article 53A of the Police and Criminal Evidence, Northern Ireland Order 1989. Can I remind members that a key element of the proposed new retention framework for biometric data is the list of serious offences known as qualifying offences as specified under Article 53A of the Police and Criminal Evidence, Northern Ireland Order 1989, which is PSNI. The designation of an offence as a qualifying offence will have implications for the retention and destruction of biometric data within the new framework. To ensure the list of qualifying offences is as complete as possible, the Department has been working with the PSNI and the Departmental Solicitor's Office to conduct an extensive review of the list of offences, which involved the consideration of what offences may have been omitted from the original list and what new offences may be suitable for addition to the list. So can I inform members that as part of this review of the qualifying offences list, the Department held a 16-week public consultation on proposed changes between May and August this year. May and August this year. 6 responses were received and the Department has provided a report on outcome of the consultation. The report states that the Department is working to finalise the list and that in order to update, the list will be brought forward to come into operation in parallel with the commencement of the new retention framework contained in Part 1 of the Justice Bill. So can I ask members if they are content to note the paper or if any further information or clarification is sought? Emma?
Chair, and it just relates to what you had asked yourself of the PSNI. Can we as a committee see what those qualifying offences are actually going to be, what that list is?
Yeah.
And has it been referred to the Human Rights Commission? Can we ask that it does?
Ask that question, yeah. Okay. Agenda item number 14, victim engagement in the parole process. Consultation on measures for improvements, Department of Justice written paper. Can I refer members to page 388 of the meeting pack, which contains a written paper from the Department of Justice giving notice of a proposed consultation on measures to improve victim engagement in the parole process. Can I inform members that in March 2022 the Department amended the Parole Commissioner's Rules, Northern Ireland 2009, to allow victims or other persons to ask the Parole Commissioners to produce a summary of reasons for a decision following an oral hearing in a particular prisoner's case. Building on that, this consultation proposes further amendments to the 2009 rules, which are aimed at enhancing victim engagement in the parole review process. The 5 key proposed measures are set out in the consultation document. So can I inform members that subject to any comments the committee may wish to offer, the Department plans to launch the consultation during December 2025 for a 12-week period. Following analysis of consultation responses, the Department will provide the committee with a report on findings and finalised proposals. So can I ask members if they are content to note the paper and to consider the matter further when the results of the consultation and proposed way forward are available, or if any further information or clarification is required at this time? Members content to leave it? Agenda item number 15, legal aid reform, improving impact and value for money for reforming scope and merits testing. Consultation, Department of Justice written paper. Can I refer members to page 3 to 43 of the tabled pack, which contains a written paper from the Department of Justice giving notice of its intention to launch an engagement paper to initiate a structured process of stakeholder engagement on a range of options for legal services reform commencing in January 2026. Can I inform members that the Department has advised that reform of the scope and merits framework for legal aid is being progressed as a key priority under the Enabling Access to Justice Reform Programme Delivery Plan. The Department has identified draft options for reform which are set out in the engagement paper. The Department states that these options represent initial policy thinking and do not constitute an exhaustive list or set direction of travel by the Minister. The engagement paper seeks views on the mitigations, exemptions and safeguards necessary for each reform option. The paper also seeks views on matters relating to provisions in the Public Office Accountability Bill and to the Competition Appeals Tribunal. The Department has advised that it intends to publish the engagement paper in December for a 10-week period to support continued engagement with key stakeholders, including the legal profession, their representative bodies and the third sector organisations and other interested parties. So can I ask members if they are content to note the paper and to consider the matter further when the outcome and next steps are available? Or does anybody need any information at this point? Okay, happy enough. Agenda item number 16, legal aid reform, a simpler, fairer approach to means testing, consultation, Department of Justice written paper. Can I refer members to page 422 of the meeting pack, which contains a written paper from the Department of Justice giving notice that intends to launch an engagement paper on a simpler, faster, fairer approach to financial eligibility testing for legal aid. Can I advise members that the Department's foundational review of civil legal services identified a range of issues with the current operation of the legal aid system. This includes evidence that the current system is deterring or preventing applications for legal aid from people who are eligible for assistance due to the complexity of the system and the time and effort required to gather and submit the required documentary evidence. Based on the findings of the review and analysis, statistics and management information, officials have identified a range of reform options that the Department advises have the potential to address these issues, which are set out in the draft engagement paper. Subject to the Committee's view, the Department intends to issue these options for engagement for a period of 12 weeks. The Department has also written to the Northern Ireland Human Rights Commission and the Equality Commission for their views on the proposals. So can I ask members if they are content to note the paper and to consider the matter further when the response to the engagement paper and the proposed way forward are available? Or does anybody want any information at this stage? Go on ahead.
No, I just want to ask, does that mean it's a 12-week public consultation?
Yep.
12 weeks of engagement? 12 weeks. Yeah. And will there also be targeted Pacific stakeholders, I'm assuming, and is there a list? It'd be interesting to see what list has been drawn up,
okay,
if it's available.
We can ask that. Mm-hmm. Okay, agenda item number 7 is Budget 25-26, December monitoring. Department of Justice written paper. And I refer members to pages 472 of the meeting pack, which contains a written brief from the Department of Justice on the Department's 2025-26 December monitoring position, submitted to the Department of Finance on the 20th of November 2025. Can I advise members that officials are proposing to provide the committee with an oral briefing on the monitoring round at the meeting on the 11th of December. So can I ask members if they're content to note the paper for now and follow up with any questions at the oral brief session on the 11th of December? Agreed. Agenda item number 18 is correspondence. Can I inform members that there is a correspondence memo and 8 items of correspondence at page 491 to 529 of the meeting pack? Can I advise members that I will draw their attention to 3 of the items, and then members then will have an opportunity to comment on any other items of correspondence. 18.4, can I refer members to page 500, which contains a call for views on the RHA closure of non-domestic scheme bill from the Committee of the Economy. Can I inform members that the Clerk of the Economy Committee has requested that all committees' responses, including nil responses, be sent to the committee by the 1st of December 2025. So can I ask members if they are content to submit a nil response? Yeah? Have enough? 18.8 then, can I refer members to page 500 to 501 of the meeting pack, which contains further correspondence from Causeway Coast Dog Rescue requesting reconsideration of committee's decision not to review or investigate animal welfare in Northern Ireland Prison Service facilities. Can I remind members that at the meeting on the 13th of November, the committee agreed to respond outlining the current pressures on the committee's work programme and the focus on statutory duties and strategic priorities, highlighting that the Department of Justice has published the findings of a recent inspection of McNally Prison by animal welfare officers on its website, and advised that the organisation should direct their concerns via the relevant organisational complaints procedures and, if necessary, the Northern Ireland Public Service Ombudsman. That's what we had advised. Can I seek members' agreement to reiterate the committee's position and that it is unable to conduct a review or inquiry, but that if they wish to do so, members could take the opportunity to raise these matters during any future briefings with the Northern Ireland Prison Service officials, and that is something that will probably come into play next year. Is that okay, members? Mm-hmm. Content? 18.10 then is that can I advise members that a number of further items of correspondence have been received from an individual relating to an ongoing personal matter. These items have not been included in the pack as no new issues have been raised, but are available in the committee office should any member wish to receive a copy. Can I ask members if they are content to adopt this approach to any future items of correspondence received from this individual which do not raise any new issues, or if they would prefer to include the correspondence in the meeting pack, or if they would wish to have it issued separately via their electronic mailboxes. This is an issue that some of the other committees are faced with too, with regards to this individual and others. So what way does members prefer to go? Do we want it highlighted in the memo pack, and then if we wish to go and view the content, we'll go and view it, or which has been done this week? Or do members want to consider another option? Or do you want to see everything on the face of the pack? I would advise against that, honestly, personally. Or do you want a separate electronic mailbox that can be either sent out to you or you can dip into? Any views?
I'd be happy enough just to see it, to view it, but not to actually have it part of the meeting.
So you could have an indication on the pack that there is a new...
There's a correspondence.
The correspondence which doesn't provide anything new, and that if you wish to, you can go and see it.
Is that safeguards us going forward for any similar types of correspondence that comes in?
Yeah, well, we need to record that we've received something. It's a statutory obligation within the committee, but you know we get big packs, and sometimes correspondence come in and can add to the packs, and that's not something we need to do. But if we're notified as members that there is a new piece of correspondence which doesn't raise any new information, then I think we're safe to have that notified in the pack. But then if we want to go and read the content, then we can go and get the content from the staff. Is that okay? Our members are
I'm happy enough.
Content?
Yeah. What's the rationale for it, that the packs are too big, basically?
No, it's because the individual has written consistently to this committee and other committees, and they're offering no new information, and we have already dealt with it countless times.
I can nearly guess who this person is. So
if you're sitting on other committees, you will have encountered them. Yeah. So it's just making sure that we have fulfilled our statutory obligations, that we as members are notified, that's in the pack. It's notified in the pack, and if we want to go and see the content, then we can go and see the content. Yeah. If there's anything fresh or new ever comes out of these correspondence, then it can go into the pack. The full correspondence can go into the pack. Yeah. Other committees.
So it's going to be flagged. It'll be in the pack if there's something fresh and new, and that'll be flagged through the Secretariat.
Yeah. And we won't withhold obviously any information. We can't do that under standing orders, but we will let you know that it's there if you wish to come and see it.
Yes.
If it does raise any new issues, we will include it in the pack.
Yeah, that's fine. Yeah.
Okay, our members then content to note the other items of correspondence set out in the correspondence memo, or whether there's any comments to make on any of them. Okay, then agenda item number 19 is forward work programme. Can I inform members that the Department's proposed forward work programme for December is at page 531 of the meeting pack, and the latest draft of the committee's forward work programme can be found at pages 532 to 537. Can I inform members that the Department has proposed 2 oral evidence sessions on the 11th of December, which would be additional to the second session with departmental officials on the Justice Bill that is also scheduled for that day. That will be a heavy day. So can I seek members' agreement to schedule a finance update, including December monitoring round for the 11th of December, and to ask the Department to reschedule the electronic monitoring update for a suitable date in January? Yeah. Okay, yeah, happy to clear the deck there. Can I seek members' agreement to the forward work programme then, as amended, to reflect those changes? Agreed today? Agreed. Agenda item number 20 is chairperson's business. Can I advise members that I have no chairperson's business this week? Agenda item number 21 then is any other business? Does any of members any other business? No. So agenda item number 22 then is date, time and place of next meeting. Can I advise members that the next meeting will take place on Thursday the 4th of December 2025 at 2 p.m. in room 30, Parliament Buildings. I can now adjourn the meeting.